look at your study guide. We're on track. We're going to do 4, 5, and 6 today. I'm going to try to knock all of those out. We might get through most of 6 because on Wednesday we really need to have a firm foothold in chapter 7. Chapter 7 starts sort of the middle part of the course that's very intense. There's agency, the idea of how agents work with clients. And remember, the Real Estate Commission exists to protect clients from us, making sure that we treat them well. So do you think they want agency to be something we grasp very fully? Do you think they're going to test us a lot on agency? They hammer agency into us all the time here and forevermore. So 7 and 8 are all about agency. Hugely important. I can't stress that enough. And if you remember in your Relink book, it's, there's my Relink book. Okay. Pages 16 and 17. Let's just take a look. You should be doing this too, by the way. Refer back to this frequently and think, okay, what chapter's coming up? Oh, 7? Well, let's look at 7. Oh, brokerage relationships. Oh, I think, in fact, this is the one from which the most questions come. 21 questions across national and state. Brokerage relationships, laws, and practice. That's 7. And then 8 is the contracts and licensing agency agreements that support the carrying out of all that agency stuff. So very important. Look out between, in fact, 7 and 8. What is that? 21 plus 15, 36 questions. Is that my math? Is my math right? That's a lot, guys. And then what's right after it? Basic contract law is 9, and then contracts and procedures is 10. So that's another 18, big chunk of 4 chapters coming. And then after that, we've got the financing chapters. So this middle part of the course, you've been gearing up in these little onesie twosie chapters. They've not been unimportant, but they've been just kind of warming you up for what's coming. And buckle up. And if people haven't been leaving you alone so far, you've got to get serious with them now and tell them, okay, for real now, you're going to have to be eating some takeout. I can't be making food for people. I can't be doing every single thing I've been doing for people. As much, you got to give me some study time and put your foot down because you need that time. Hopefully you've carved out the right time schedule that works for you. Sometimes it's getting up a little earlier. Sometimes it's staying up a little late. Sometimes maybe it's studying over lunch in between this and that and the other, but all the more important to do from here forward. Gear it up. I've also gotten a little feedback from people that the comments section study is getting a little challenging. How do we feel about the comments? You can put that in the chat. Tell me, are you challenged by the comments, by the license law and commission rules material? Is that getting kind of hard to understand? And you don't forget, you can certainly direct message me in the chat. You just highlight
too many
that little,
details.
yeah, right. That's what it's all about. That state, North Carolina is supposedly one of the more difficult states in licensing testing. So I'm going to go over that with you, everyone, and kind of show you comparing the syllabus with the comments section. So maybe give me after the first break today, I'll get myself set up for that, and I'll give you a little insight on maybe how to compare, how to study, follow the syllabus, follow the comments, and how to compare and reconcile the two. So I'm going to talk to you about that a little bit later. There's a whole lot of detail, but I think after you kind of get a feel for it, it'll make a little more sense. Some of those syllabus items can be lumped together. So
Remember, we need to see your face. So some of you, I just see the top of your head. Just tilt the screen a little bit so we can see all of you.
thank you. Good point. This is being recorded. Commission can audit this at any time, so we have to make sure we are in
Thank you,
compliance.
Ashley. That's perfect.
Lovely.
Talon, can you adjust a bit? Little more. Great. That's great. Thank you.
So here's our syllabus. Section 21 is the license law and commission rules. You'll notice it says that it's level 2 information unless it tells you otherwise. So then two spots down is that it's level 1, which just means definitions. What's a provisional broker compared to a full broker, compared to a broker in charge? And the reference back to the license law that sets that out, 93A-2A, A1, and A2. So I would say go down through the syllabus, see something like that. If you can't immediately think of the answer, because we've covered the first 3 sections of this part of the syllabus. We've covered A, B, and C here. So review yourself on what you know. Maybe flip to this nice blank page of the syllabus and see what you can fill in to these blanks. What is a provisional broker? Write it out in the margin compared to a broker. What does it take? What's the education requirement to flip from provisional over to full? And then what is this thing? We haven't seen that weird phrase in a while. Not limited, non-resident commercial broker. And then licensing of business entities. What can you remember about that? Oh, nothing? Okay, just can't quite grasp it. Then go back to 93A-1. Or first of all, my first stop would be the comments section. Follow along in the comments section as you're looking at the syllabus and see if you can locate it there. And then also go to the license law 93A1 and the commission rule 502. And then highlight in that and then write a little note here, right? You have to be proactive with this thing. It's like you're writing a research paper. If you remember writing research papers, whether that was in college for you or maybe high school or writing any paper, you had to do some background and some digging. You had to sift through a whole bunch of information so that you could fit everything you're supposed to do in like 5 pages. It's hard to write efficiently. It's easy to just go on and drone on and have a 20-page paper that says like 3 things. But if you can say those 3 things in 2 pages, that's impressive. That's like college level. That's what you're doing here. You're sifting through a whole bunch to get down to what's really important. What document am I referencing? Oh, thank you, Jennifer. I think you handled that. The thing that we're looking at now, did that answer your question? Okay, there we go. Found you. And then, see, these things under number 2, A, B, and C, they're going to require you to dig and get some definitions. And then number 3, all of these 6 things, A through F, those are all answers to the question 3, activities requiring a license. What requires a license? So it's sort of like you could draw a whole big circle around number 3. That's the potential for 1 or 2 questions. They could say, which of the following is an activity that does not require a license? That could be a way the question is worded. And then you're going to need to know these 6 things so that you can find which one is indeed not in this list, right? So I kind of see this number 3 as one big thing, one big bullet point. As opposed to up here, I see number 2 as the definition of provisional, broker in charge, limited non-resident, and entities. I see that as 5 separate things, where I see this number 3 sort of as one big thing, if that makes any sense. I don't even if that even helps. And then number 4, we went through a whole big list. I mean, that's just one little point. Permitted non-brokerage activities of unlicensed. What can unlicensed people do? What real estate activities are allowed for unlicensed people to do? We covered that. It took us a while to get through that list. It was probably 10 or 12 things or more. And then number 5, what are the exempt activities? That one to me also feels like one big question, because it's just this list of, 8 things, that exemptions where people who do not have a real estate license are still legally allowed to do real estate. A trustee can carry out the needs of the trust. that require real estate activity, which normally would mean they would need a license, but they don't because they're a trustee. And an attorney at law and an attorney in fact, someone to whom has been given the power of attorney. And then we talked about B, who is on the commission? What is that? How many people? And what are the what's the rotation? And how are they appointed? Are they elected? No, they're appointed. Who appoints them? Their powers and what is the disciplinary authority they have over us? You tell me that now, if you don't mind, in the chat. Give me some of those four. I'll give you a hint. There are four of them. Disciplinary actions they can do over the licensee. Let me double check that tweet about the version. Just look, is this not matching up to your pages? Okay. It might be, I'll double check that. Yeah, there we go. Censure, revoke, suspension, and then one more, the lightest one, the one if you had to have one that you would want. There it is, reprimand. You got it, four of them. Now there is a fifth actually, but it's only limited to one specific type of licensee that they can do this fifth one. What am I talking about? What can they do? There it is. They can fine a timeshare developer. And do you remember how much that fine is per violation, by the way? You're good. You're nailing it. $500 per violation they can fine a timeshare developer. That's the big exception to the fact that otherwise the commission cannot and will not fine us. They'll do those other four things and various conditions of those four things, but they won't fine us. So I'd say when it comes to this, first step, go back through, fill in what you know without looking. Put a question mark of things you need help with, then go back and gather up the answers of the things that you don't know. And then section C, remember this note. It is not discussed in the comments or comment section. So if you were to master and memorize the entire comment section, it's like 30 pages, it does not include these 10 items. So it needs to be what you see in the comments plus this section C. But it's all the easy stuff. It's the stuff we learned the first 30 minutes of the first day. What is a provisional? Pre-licensing versus post-licensing. What happens when you don't take your courses that are required? Your license goes from active to what? And the difference between inactive and expired. Don't call them different things. That's an easy question to miss, and it's an easy question to get, right? It's just straight up have it down, because if you don't do the education, your license is inactive. And if you don't pay your $45 by when? When do you need to pay that $45, by the way? If you don't do that, your license does not go inactive. What happens? What's it called when you don't pay the money by June 30th? Thank you. It's expired, like a parking meter. Parking meter expires when you don't feed it money. The real estate commission expires your license when you don't feed it money by June 30th. And what's the deadline for the education called CE, continuing education? It's not June 30th, it's June 10th. And here's a commonly missed question. This one is commonly missed by post-licensing students. This one is also commonly missed by forever and ever in the business agents sometimes. Oh my gosh, I taught a bunch of CE last spring, and I heard this incorrect answer every time. Several people in every class got this wrong. Here's the question. If you don't do your continuing education by June 10th, you wake up on June 11th and you remember that you screwed up, is your license active on June 11th if you miss your CE by June 10th? Are you still active on June 11th? Good job. Great. See what I mean? You guys have an advantage. You might get tired of hearing some agents ask you how long you've been in the business. I did when I was new, but don't worry about that. You know the laws and rules better. and brag about that in a good way, right? Point that out to people. That might be the way you counteract their objection. If they say, "You've been in it less than a year, why shouldn't I hire this other person? Because I probably know the laws and rules better. I just got out, right? And I'm going to give you all my attention. I don't have 45 deals going. You're all, you've got all of me, right? Point out your pluses. Go ahead, Margie.
Okay, I have a little something that I tell all my newer brokers what to say. When somebody says, "So, how long have you been in the business?" Now, I want you to really remember this, and I want you all to be looking at me. So, Neal, ask me how long I've been in the
How
business.
long have you been in the business?
You know, it seems like forever. And they will laugh, and you will laugh, and then just keep going. What if you're at a listing presentation or whatever you're doing? Let them laugh, and you keep going. Because, my friends, it will seem like forever. Okay, just a hint.
That is true. That's probably the best answer I've ever heard about that objection. Because you know what? When it comes to these objections, people aren't asking you most of these questions because they really want to know the answer. They're asking you so they can feel justified in picking you because they probably like you and want to choose you. And so they just need to feel like they did some research and maybe be able to go back and tell their dad that they did their research, or their friend, or people tell them you need to interview people. If they like you, they're going to throw that out the window. So sometimes they just ask you questions because they think they're supposed to be asking you questions. As long if you can just glide right on by it, I'm not saying neither of us are saying to lie. We're saying some things don't need an answer. If you can laugh it off, don't just keep on going. Doesn't matter. It really doesn't matter. There are plenty of 20-year veteran agents in the business that are no better than when they were in their first year because they didn't work on it. They're basically a 1-year agent 20 times over. Let me qualify. They're basically a bad 1-year agent 20 times over because there's a lot of really good 1-year agents. So hopefully that helps. Combo of recap and ego boost or pep talk. That's what I'm looking for. Somebody asked where to find the comment section. Remember, any sort of documentation you need can always go back to Notion. Let me scroll down through here. Oh, here we go. On the left, required texts, and then you've got your link to buy the textbook. No, that's the non-issue for you. There's also the syllabus here. I hope you can see that on the screen. It's kind of small. The license law and commission rules next to that, the relink book next to that, and then the practice. It's just me talking to you about the practice exams. Also, in the main body here, if you scroll on down in your Notion, you'll find the link to, there it is, the Google Drive. If you click on that Google Drive link, I've got a bunch of stuff here for you. All the stuff we've talked about. The study schedule, the policy and procedures, the comments section. You can find everything in the Google Drive. I added some stuff this weekend. One of those things is the listing agreement, a sample listing agreement. We're going to get into that in 7 and 8, more specifically 8. And also the offer to purchase and contract. That'll be from 9 and 10. And between now and next week, I'd like for you to look at both of those. Kind of just go down through and circle like the hit the highlights, some things that you think are really important in these two publications. And then if you keep on going, oh, yeah, something we're going to also talk about in Chapter 7 are those last 3 items, the working with real estate agents disclosure. And we'll learn then that is, I would say, the most important document that the Real Estate Commission wants you to talk about first when you meet a new prospective client. Because that is the thing which tells them the fact that they shouldn't tell you anything yet. The working with real estate agents disclosure is a warning to prospective clients. Don't love me too much yet because we haven't decided how I'm going to work for you. You haven't hired me yet, so don't tell me your confidential information. And that's huge. You know what? I was talking to an agent yesterday. She's also an educator at a different school, and we were talking about this very thing. And I said, every time I teach a CE, I ask this question: Hey guys, the last time you spoke to a client and they had just worked with someone else before you, and then you started explaining to them the working with a real estate agent's disclosure that's required, how many of them said something like, "Oh, I've never heard of this before. The last agent didn't tell me about this." Everyone, every class has a handful. So a lot of our colleagues are not doing this right. A lot of the 80,000 active licensees across North Carolina are not doing this. They're getting lazy. And the commission would have a big problem with that. If a complaint happened and it came out that they had not even covered this material, it's hugely important. So you can take a look through that because we will be going into great depth. There's also the residential square footage guidelines. It's a little yellow book in printed format. But here's the PDF. It shows us what we are required to know in terms of measuring houses. Do you remember the question, are we required to disclose square feet? Is it a material fact? Tell me in the chat, is square footage a material fact that we have to disclose to people? Let me make a better question out of that. Is square footage a material fact as per the Real Estate Commission? Does the Real Estate Commission want us to disclose square feet? Guess what? They don't care. They say, whatever. Some places don't. They don't even talk about square footage in certain other markets. So the Real Estate Commission says, we don't care if you disclose it or not. It's not a material fact as far as we're concerned. However, if you do disclose it, what we care about is that it is accurate. Well, why do you see square footage in every listing sheet that you look at when you're perusing North Carolina real estate? Because the MLS requires it. The local multiple listing services require it. If you want to post a listing in there, you got to put in the square feet. Oh, now the Real Estate Commission cares because now that square footage has to be posted as per the MLS rules, the commission says, well, then it better be accurate. That is another testable question, right? Is it a material fact as per the Real Estate Commission to report square footage? No. All they care about is that if it is reported, that you accurately report it. You, the broker, are responsible for it. You can certainly hire it out to be done. We'll talk about that later. But you are still responsible. Make sure you hire somebody good at it. So there it is. Hopefully that helps. That is the location of every document I ever give you, that Google Drive. And you can find the link to it here. In fact, you could, once you go to it, you could, if you see I highlighted in that upper address bar, search bar, cut and paste that thing and store it away somewhere. Then you don't have to go to Notion every time. You can just plug it into your search bar or save it as a bookmark. That's probably even better. I'm going to keep on giving you video supplements along the way. I think that kind of answers questions nice and fast. If I can answer it quicker than that, I'll just give you a couple of lines of typing it out. Like here's a little note. Check the Google Drive to see a sample offer to purchase, because I had talked about an offer and I walked you through a little bit of it when I did this video on the question and answer, a couple of questions that I had gotten. So is that working for you? Are these things helpful? Okay. If I'm doing so, I don't want to do it just to do it, just because I can, just because the technology is there. It needs to serve you. First and foremost, the technology has to serve your needs. So if it's tech for tech's sake is nothing that I'm interested in. So keep me posted if it's like, this is cute and bells and whistles, but it's not helping me. So keep me posted about that sort of thing. All right. Questions? Any questions? Oh yeah, the massive fail of that Kahoot poll effort. I don't know what the heck happened there, but hopefully you saw it was just 3 questions. It wasn't review. It was just to me to get an idea of what you guys need because I want to check in like I just did. Let me know along the way what can we do better. Are you running into any certain roadblocks, obstacles, issues? Okay, good. You like the Kahoot game. I'm going to do more of those for as a review, and I think it's helpful to do them where I send them to you. It seemed like, as far as I know, that poll Kahoot was the only one that just completely went belly up. All the other ones seemed to work okay. I'm looking at faces, looking for head nods. I think good. So I like it because I think it's a little more interesting, keeps you from falling asleep. Some of these polls are ridiculous. Let me just, um, we're also going to do the Zoom poll type. So as an example, let's do one on Unit 3 real quick. If you look at your screen, I just launched it. Hopefully that worked and you see it. And you can just scroll down through. It's only 10 questions. Go down through and answer these to the best of your ability, and then we'll talk about it. And you'll notice that these are anonymous. All this shows is what percentage of the class answered which questions. So you will not be called out. Just like on Kahoot, you can always put in an anonymous name. I'm not looking to give you points or take points away for any answers there. It's purely as a swing, as an at bat sort of thing. So you can be anonymous on these things. Sorry about that. If you lost it, it might be that it bumped behind another window. You might want to look around in your other windows, but worst case, we'll be going over the answers in a minute. So you'll still get the benefit of it. You just can't participate unless you find that again. Sometimes they don't even pop up for some folks, and it little weird technology gremlins, I guess. And it tells me how many folks have answered. I've got 18% so far. I've completed everything. So just keep on. We'll go for another couple minutes. Okay, let's go ahead and end that poll and I'll share the results with you. We'll talk about it. So hopefully you can see the window where I'm sharing what you all answered anonymously. In North Carolina, the law that determines the rules for property taxation, it's really just the name of the legislation that was passed years ago that said, here's how we're going to handle property tax in North Carolina. And that legislation included a bunch of other stuff too. But the Machinery Act, think of it this way, the machinery of the taxation system. The system of taxation, meaning what date does the tax rate change, or if it's going to, when do we change the tax rate, what month? When are taxes due? September 1st, all the way up till December 31st. And just the whole process of taxation, real property taxation, and that is called the Machinery Act. The Machinery Act. See what they did to you? They gave it a name that sounds like it makes more sense than, than the actual name. So you have to know this stuff so that you don't fall victim to these decoy answers. I mean, gosh, 2 out of these 4 possible answers make more sense than the actual real answer, right? Property Taxation Act is a much better name. Public Taxation Act also, but Machinery Act is the right one. Property taxes in North Carolina are based on which of the following values? Well, most recent sales price, that would be what we call the market value. So that's not it. That's not it. Sales price is not it. That's just what a buyer was willing to pay for it. And so the tax record is something you have access to. You could search property tax records of Cabarrus County, Mecklenburg County, whatever county you're in, and plug in an address and see the tax record. It's public record. And you can see what the tax value is of every property and also what tax amount they have to pay or had to last year, maybe even for the last 2 or 3 years. It's right in there. It also shows the basics of the house, square footage, 2-story versus 1-story. Does it have a garage? What's the type of siding? And what I tell people when I go on a listing appointment and I show a seller their tax record, I say this: take a look at this sheet. It's wrong. There's something here that's not quite exactly 100% right. It's probably the square footage. The government probably thinks you have less house than you really do, and you're okay with that because it all goes back to your tax value. You're paying taxes on a smaller number because they think you have 1,800 square feet, but you really have 1,900, and that's okay. It's just the way it works. So the tax record reflects what it sold for last time, however long ago that was, but it also shows this is the assessed value, the value at which we are going to calculate the tax bill every year. Thank you, Margie. Take care. So to say the most recent appraisal is probably not a good enough answer because what is the purpose of the appraisal? Appraisals are done for lots of different reasons. And when you see the term assessed value, that does not mean some tax guy came out and looked at the property from top to bottom. They don't do that. They don't even go to a house. They might do a drive-by every now and then, but for the most part, they're just relying on what information is already in the system. And if you filed any permits for work being done on the house, then they'll reassess and maybe add some more tax value to your house because you put in a garage or you put in a sunroom and you had to get a permit to do that, and they cross-checked it with the permits, the building permits. Most recent tax bill is probably not the best answer. The best answer here is most recent tax valuation. So good job. Most of you got that. Good job. Property taxes in North Carolina are due and payable on which date each year? By far, September 1st is what you got. July is the month in which the tax rate is going to be disclosed if it changes. It'll be whether it changes or not. So it won't necessarily change every year, but in July is when you find out what the tax rate is. It's 13 mils, or in this area that I'm in, it's $1. Well, it'd probably be, I don't remember what my county rate is at the moment. Maybe like 93 cents per $100 for the county, and then 17 cents per 100 for the city rate. That kind of thing will be disclosed, come out in July. What about these other ones? And by the way, notice what I'm doing here. When you get to the point of having some test questions to work with, don't just stop when you see the right answer and move on to the next question. Look at the wrong answers and think to yourself, what would make this the right answer? You're going to get 4 times the mileage out of your sample practice exams if you do it that way, right? Even if you have to pull open a book and look for the right answer, do it like you're trying to be me and you're trying to help people and test people and think, how could I make another test question out of this? So September 1st is the answer for this question. That's when the tax bill is due and payable, but it doesn't have to be paid on September 1st. That's just when you can start paying it. That's the first day you can pay it. That's the day my wife would pay it. The day I would pay it is closer to December 31st because that's the last possible day you can pay it. So that's all there is about December 31st. From September 1 to December 31 is the time frame within which you can pay your taxes without penalty. And they don't care any time during then when it is. Most mortgage companies who pay on your behalf, because maybe you send your payment in as a PITI. Does that sound familiar? Principal, interest, taxes, and insurance. You ever heard of that phrase? The taxes and insurance is collected by your lender most of the time. And they just stick it in a little escrow account until it's time to send off the full bill. And when it comes to this tax bill, am I pointing in the right direction? You have no idea. How about we share that? Okay, there we go. Nope, that's not it. I can't even show you the poll. Okay, sorry. Having a little company meeting all in my head right now. When you pay your mortgage payment, the lender sets aside each month's worth of taxes and insurance, and then they're going to send off the full amount when it comes due. Those mortgage companies aren't paying it in September. They want to hang on to that money in their account, probably an interest-bearing account for all we know, until probably like December or November. January 5th, what is it about that date? That's the date that if you still haven't paid last year's taxes by, you're going to get published in the paper by January 31st. So January 5th is when you're officially past due. And then July is when the rate comes out. July 1st doesn't matter, but the month of July is when that rate comes out. In North Carolina, how often must the tax value be reassessed? It's called octennial reappraisal. Octennial, octo means 8 years. Good job. So what happens is every year for a while, tax values might be kind of similar or maybe even the same. But in the meantime, between now and 8 years from now, there's probably going to be a few more subdivisions that go in, right? Maybe a few more people that need school, public school, maybe a few more miles on the roads that have gathered potholes. There's going to be a need for more taxes to be collected so the government can support the increase of people. And there's more property. The values have gone up. They're taxing you on a value at $250,000, but now the houses are worth $350,000, and the government wants their cut of that. They want to get taxed. They want to charge you taxes on $350 instead of $250 now, because it's been like 8 years since they last put a valuation on your property. So the answer is 8 years. In North Carolina, how often may the rate for property be adjusted? Every year. Could be every year, not necessarily. So it probably is going to stay the same few years in a row, but it's every year in July is when you find out what the rate is going to be. Tax rates expressed as mil would be calculated as a fraction by doing what with the calculation? Remember, the big difference between the two kinds of tax rates is what you divide it by. The first way we learned was pretty easy because it's literally in the name. The rate of the tax rate called dollars per hundred, per like divide by, 100, literally 100, so divide by 100. The other one that we learned is the mil rate. That's the divide by 1,000. Most of you got that. Good job. Tax rates expressed as a dollar amount would be calculated as what? And that's the dollars per hundred. So there you go, per hundred. And then a mil rate of 13 would be calculated as which decimal amount? Okay, on any given number in the whole world, like this, like a whole number, where is the mystery ghost decimal point? There's a decimal point hidden from view in every single number, and it is after the numbers. So 13.0 is the same number value as 13. So that decimal is after the 3. And if we move it 2 spaces to the left, 3 spaces to the left, sorry, because we're dividing it by 1,000, not 100. If we move it 3 spaces to the left for when we're doing mill rate, it gives us 0.013. You could have also just plugged it in the calculator, which I would advise you do as a safety net. Don't try to be a big shot and answer it like I just did and got it wrong. The fatigue of the test after the third hour, just go ahead and double check and plug it in the calculator. There's no shame in that. I would dare say most people are the incorrect version they're going to run into is the 2 zeros here instead of just the 1. A tax rate expressed as $1.30 per hundred would be calculated as which decimal number? Okay, now the decimal is actually visible, 1.3. Now let's push it over 2 spaces to the left, and there is our 0.013 again. Good job. Which is the same. So $1.30 per hundred is the same tax rate as 13 mills, I think is the point we're trying to make here. So my city expresses tax rate as $1.30 per hundred. So does Charlotte. But I've seen and heard of some cities a little further east, maybe east of Albemarle. Some of those counties out there, they will actually do it in form of mill rate. You could Google search it if you're curious. What mill rate in North Carolina? They might reveal, like, it doesn't matter. You don't need to know it. But there are some places in our state that use mill rate instead of dollar per. And then finally, which of the following would be among the first liens to be paid prior to all others, regardless of recordation upon transfer of a property? Good job. By far, you guys got it right. Always, for the purposes of this test, number one position is the lien that could be placed on your property by who? The government. Who wrote the law here? The government. So they put themselves first. That's my little snarky way of remembering this question. Right? The guy who makes the law puts themselves first. The golden rule, he who has the gold makes the rules, right? And then what's the number two position, by the way, as we are getting more mileage out of this test question? Is it in here somewhere? We got the number one is property tax. Number two position is what? If there's money owed to some folks, many times there's more than one lien on a property because somebody's in bad shape. They're owing money to everybody. Yeah, there you go. Thank you. That last one, government special assessments. The government said, oh, we put sidewalks in front of your house and everybody on your street. Therefore, you have to pay for that because it benefits you. You're going to have to pay $200 a month for the next 3 years. That's a special assessment. Or street lights. You could also have a special assessment put upon your property on behalf of the HOA. That's a private special assessment. The government special assessment is more of a public thing. And that's the one that has the number two position behind property tax in the priority of liens, right? Not the HOA one. Don't just see special assessments and think, oh, that's it, and not read further. Be careful that you read all of the answer choices on every question. Because if you were just to scroll on down through this one and you see special assessments and you stop there, and maybe the question is not the first liens to be paid, but what is the second lien to be paid, and you answers that, number 3, C, that would be wrong because you didn't read the fourth one. I can't imagine you would do that, but some people get in a hurry, they get panicked, they act crazy, a little different, a little stressed during the test. So try to have some just sort of a guideline in your head. Here's the procedure of taking the test. Read the question. Brilliant. Identify what it's asking for. Probably the last sentence of the test question. Read through all the answers and probably scan back through that question one more time. Here's another thing. This is all good to know. Stuff that you might want to make notes of in your little journal that you have beside you as you're looking for the nuggets that I'm throwing out to you. Read through the question, read through all the answers. Oh, they're going to many times give you more than you need. They're going to give you more information in the test question than you actually need. So be aware of that. Don't confuse yourself and freak out by thinking, oh, they talked about tax value on this question. How does that matter here? It may not. The question might be about something totally unrelated. because when we get into math calculations, they will often give you more that you need than you need to calculate the thing they're asking for. They'll say things like the mortgage rate, the interest rate is 6%, the tax assessment is 640,000, the tax rate is 13 mil, and you only needed like one of those pieces of information. So you have to have enough mastery of the material to know which thing you don't need in any given question. So when you're taking practice exams and the midterm and you print off the PDF to do it by hand, which is probably smart, strike through those things. Since you have the ability, cross through the things you think are the wrong answer. Many times also testable, test taking technique here, many times you can easily eliminate one, if not two or more, probably at least two of the four possible answer choices. And now you're down to a 50-50 chance. If you have no idea what the remaining two, which it is, you've at least increased your odds, right? So we'll do some more of those Zoom polls. They're not as pretty as Kahoot, so I will be making more Kahoots for you guys to do on your own time. We might do some Kahoots in class. It just takes some time, obviously, that's very precious. We want to spend our time on just the absolute most important stuff in any given moment. So speaking of, let's get into today. We talked about legal descriptions. And very importantly, there are three kinds of legal description that we acknowledge here in this state. What is it? What are the three kinds of legal description? There's informal references to a property, but the street address is an informal reference. The tax parcel ID number is an informal reference. Name some one of the three, some of the three legal description possibilities. Kind of giving you one right now. You could certainly refer back to a previous deed. There you go. There you go. The best one, the one that's preferred, is the meets and bounds description of a property. It looks like what we saw in a sample deed, I think, last week, where we saw it was written down starting at the stake at the corner of X Street and Y Street, proceeding 13 degrees east for 300 feet, and then 46 degrees west for 500 feet, and continue that paragraph, that writing continues on until finally you end up back at the first point. In fact, when it comes to a meets and bounds description, it's not complete if it doesn't close the shape, right? Got to end at the starting point, because in the description, stand by. Be right back. There's what we want. Okay. In the description, it's going to pretty much be a starting point, the intersection of maybe a street, and a stake is in that intersection, and it's going to say proceed 300 feet this degrees east, and then this many degrees southeast for this long, and then go this way, and then finally back to here. So the point of beginning has to be the point of ending, closed shape. If you don't have a complete one, you'll end up like this, and it's like, okay, is that the whole world? Because watch this. Make sure I close my shape. In this little art program I use, oops, it didn't work. I failed miserably. If here's our closed shape, if I drag the color, that's sort of the idea. If I try to drag the color in this shape, it does that. So that's sort of the idea. We need a finished closed shape. And then also prior reference to a previous deed. And then also reference to a plat map, recorded plat. Thank you. Good job. Informal references, we talked about the stuff that you are normally used to seeing a property referred to by. Surveys are important. It's not just the size of the lot, but also any easements and encroachments that exist on that lot are revealed by a survey. And then it's really tempting when you see that nice little cute drawing called a survey. It's really tempting to try to help somebody interpret it, because it looks like, here's the street. They'll show the street, and then they'll show the lot size, and then they'll show it'll be a little driveway, and here's the house, and it talks about this setback. It's like 20 feet from the street, and then it's got the dimensions. This dimension is 180 feet by 200 by 230 by 197. And by the way, when you see lot dimensions, this front one, the street frontage, the front feet is different than square feet. Front feet is just the part on the front. It's just that first one. So the dimensions on this lot are written this way: 197 by 180 by 200 by 230. The first dimension mentioned is always the one on the street, the front footage. The first dimension they mention is that, and then you go clockwise. So front footage is different than square footage. Square footage would be, as I get rid of all this mess, square footage would be the square feet of this entire lot. Front footage is just this distance here. We'll see that in a minute. But you've got that survey. Don't just pull out your little business card and make a little mark of what 10 feet is and start helping them lay out their fence. That's called interpreting the survey. And it's just as bad as legal language that you're not allowed to do either. We're not surveyors. Therefore, let the attorney or a surveyor give them advice on what that survey means. Should be done. Want to make sure that it's done and they have it, but don't give them advice on it. That's what stay in your lane means. That deed is the same as the title to your car. It's proof that you own something. Proof that you own that property. Conveys your rights of ownership. Conveys that bundle of legal rights. It also is your legal proof that you own it. It's what helps you retain ownership so that you can prove to the powers that be that, yes, this is mine. The common law says that the deed or the title has been transferred when the deed is delivered to the new person and they have voluntarily accepted it. That's the official, and that's the type of question that could show up on the national part of the test. This is the type that would fall under the state part of the test. In North Carolina, this concept of voluntary acceptance of the deed is officially acknowledged, or it's considered to have happened when the deed is recorded. Because here's the chain of events for a closing. That whole time under contract. Okay, let me back up. House is on the market. You take your buyer to make an offer. It works. You have now a contract signed by both parties. It's communicated. It's acknowledged. Now we're under contract. Fast forward to the closing day. During that under contract period, the attorney has been doing what's called a title search to make sure that there's no clouds on the title, there's no encumbrances, and if there are, have we made provision for that? Do we have permission? Do we need to handle some sort of a legal document to get permission from the neighbor that we're over the line? Are there any other parties that are claiming ownership? Is there a tax lien on it? Is there a mechanics lien? All of that stuff is what the attorney is discovering. We as brokers, thank goodness, don't have to do that. We need to see how it went, but we are not doing that. The paralegal's doing it. The attorney is signing off on it. So at closing day, hopefully everything is good, and the attorney's like, okay, we got it all worked out. There was a problem, but we got it figured out. Somebody just had not reported something and blah, blah, blah. Things like that happen. So now it's time to sign papers. Also, what has been happening on the buyer's side is that loan process, if there's a loan. That lender has been gathering up all this financial data all these things. Anybody gone through the loan approval process? It's a million things, and everybody's a criminal as far as the lender's concerned. You still have to jump through the same hoops as someone who has racked up all kinds of debt and committed fraud. That's just the way it is, right? So they've gathered all that up, double checked everything, and they have created a loan package and sent it to the attorney. And the paralegal has gone through that loan package, and now the attorney sits down with you and your buyer, and they point out to your buyer where on the page, on the stack of 2 inches worth of documents, that they need to initial and sign. What if your buyer says, "What? This deed of trust, also known as the mortgage," we'll get into that later, "I don't like what that says. I'm changing it." No, you're not. You're either accepting it or you're not. You're either closing or you're not. There's no changing some of this stuff. We're past all of that. So if they don't like some of this stuff, the deal's dead. But they're probably not negotiating with the new lender to change anything in the mortgage document. Sometimes people want to read that whole thing, and that's okay. Read it. But let's not try to read it today. Let's try to find out, did they want to read the whole thing? Some personality types require them to read every word. Okay, great. You know this about your client. Then get a hold of it before closing day and let them read it till they fall asleep ahead of time. That doesn't happen 100% of the time. So we're reviewing all the documents, getting all the signatures. Once everything is signed, the attorney is sending all of that, scanning it all, sending it by email to the lender, who is making sure, yep, looks good. They signed everywhere we wanted them to. We will now release the funds. Now the house has the funds, and the buyer has also probably had to bring a check for their portion, their down payment, whatever amount they need to bring, which we will learn how to calculate in chapter 21. I think that might be a different chapter now. In the real estate calculation chapter, we'll go over the numbers that you need to calculate. That's probably where most of those 8 calculation questions are going to come from. How to calculate something called prorations, tax, escrow accounts, fun stuff like that. The attorney, the lender has funded the loan. The attorney can now go to the courthouse, either electronically or in person, do one more last minute check, see if any other liens have gone in at the last second. Then they will, as long as it's all still clear and no extra liens have been added to the property that need to be dealt with, then they can record it. And then they will send out an email to us brokers and say, we are on record. It has been recorded. Your client can pick up their check. Your seller client can get their check now. It's okay for the buyers to get the keys now. And oh, by the way, not that anybody cares, now is okay for you, broker, to get your paycheck. You're not done either, by the way. You're not going to get your paycheck from that attorney and then going straight to your bank and depositing it. You've got to swing by your office, and because the check is made out to your firm. Then your firm will give you your cut. But it's still a good thing to celebrate. We're happy. It recorded. That's what recording is. That's what we mean by the deed has been recorded. Some more words. I think we talked about some of these as we get into the new stuff. Alienation just means you're selling it. You are separating yourself from the property either by giving it to someone or selling it to someone. Voluntarily means you're doing it and it's happy. You're either giving it or selling it and you're happy about it. Involuntarily means they're taking it from you because court action, some sort of a legal process. It's like a penalty kind of a thing. Executor, when it comes to an estate, is the person who is probably a child, probably an adult child, the responsible one of the three, right? Not the one that's flaky, but the one that everybody expected would be given this responsibility, is the executor of the estate, carrying out the wishes and the provisions of clearing of settling the estate. And that process legally of doing so is called probate. And then someone getting property is the beneficiary. In North Carolina, if you die without a will, it's called intestate. Having a will when you die is called testate. Dying without a will is called would also lead to involuntary alienation because in North Carolina, if you die without it, thank you, Darnell. I blew right past it. If you die without a will and without heirs, the state takes your property. They get it in the form, it's a word called escheat. Escheat. Okay. Welcome back. Welcome back. About that time. Okay, to call your attention to the comment section, the question was, under this common law title transfer idea, the deed is delivered and voluntarily accepted. What does it mean? And that's a great question. It's a weird way to think of it. It's really just sort of the legal concept that we're talking about here. So as I wrote there, so if you just want to maybe take notes based off of that little paragraph, the seller has proven that they want to sell. That's the delivery. They have provided the deed with their signature on it. Remember, the only one who signs the deed is the seller, the grantor. So that's the delivery. The acceptance in North Carolina is the point at which the deed is recorded, because they've given the attorney permission to record the deed, basically. So it's just sort of a legal concept more than anything else. That's how it's carried out. That's what the concept is. Hope that helps. Let me know if I can do a better job explaining that one. Okay, where are we at? Here we go. And then dying, testate means you die with a will. So you have had, you, the one deceased, looking down from wherever, have voluntarily alienated the property because you've said, here's where I want it to go when I die. I want it to be given to so-and-so, my heirs. Voluntary alienation. You had a say in it. You've chosen to transfer the property, whether through your death in a will or through your life when you choose to sell it or give it. You could also give it. Involuntary is against your wishes, usually court ordered. Lien foreclosure, when you sign your mortgage in North Carolina, that mortgage is called a deed of trust, not a mortgage, but it's the same kind of instrument. The overarching provision in that document, and what most attorneys will explain it as, they'll say, if you don't keep paying your payment, you can't keep staying. If you don't pay, you can't stay. And that is the entire foreclosure process. That's what it's all about. They agreed to let you borrow 6 digits or more, right? $600,000, $300,000 in exchange. If you don't keep up your end of the bargain by making your monthly payment, at some point in you falling behind on your payments, they can choose to initiate the foreclosure action. How many payments do you have to miss? It depends on the lender. It's their choice. They could do it after the first one, but they probably won't. Most of them might give you a couple or 3 to catch up. But it's not your say. It's not necessarily in writing. They can just choose in a business decision, look, we need to go ahead and foreclose. Adverse possession is that weird sort of squatters thing we talked about. If the property has a cloud on the title, then that person who is using it adversely under the OCEAN acronym only needs to do so for 7 continuous years. That was a long sentence. If the property has no cloud on the title, then they're going to have to do the acronym worth of things, use it openly, continuously, exclusively, adversely, and notoriously for 20 continuous years in order to have a shot at going to the judge and saying, now I want it, give it to me under adverse possession. Here's the word for when North Carolina takes your property because you died without a will and no heirs. Escheat, the reversionary right when the property is abandoned. And then here's this concept of eminent domain. The government condemns your property through eminent domain as long as the use of it intended is for the public good. Can't just be because they want the money. It's got to be for the good of the public. And then they have to compensate you. Your definition of fair compensation might be different than theirs. It often is, but they do get an appraisal. They do verify, justify, and say, here's what we think it's worth. Here's what we're giving you. We're taking it whether you want us to or not because it's for the public good. And you do have access to due process. You could challenge it. Good luck with that. Essential elements of a deed. We talked about that a little bit. All of these things. In writing, needs to be in writing. Grantor must be 18, sane, and sober. Legal capacity means 18, legal age or more. Legal age as of 18 or more. Legally sane. I know we all have people in our lives whom we doubt that particular aspect. And then sober. Were they sober, free of intoxication when they made a decision, when they signed something? And they have to be identified. The deed does spell out who's the seller, who's the buyer, but only the seller signs. Grantee does not sign. Must be identified through a legal description, the property. Adequate words of conveyance. What is the point of this deed? Must be expressed. It can't just be a piece of paper in writing with the names of seller and buyer signed by seller. That's not enough. The words have to support what are you doing with this document. And then delivered and accepted. And here are the non-essential elements, most of which, if we were writing up the law together, those of us in this room, we'd probably say all of these need to be done. But this is just the way it is. These are the non-essential elements, but they are probably on there anyway. Doesn't mean they can't be on the deed. Just means that they're not essential. It's not a deed because these things are there. In this list, it's a deed because these things are on it. If these things are not on it, it's not a deed. It's not a valid deed. That make a little more sense about wording it that way. But if these things, these non-essential elements are missing from the deed, it's still a valid deed. Think of it that way. Dated, witnessed, recorded. Oh, wait. Recording is a non-essential element, but yet in North Carolina, it must be recorded to be acknowledged, delivered. Yep, true. Really good test question. And terrible, depending on your perspective. So make a note here. Recordation is required in North Carolina for it to be on the record and for it to be considered having been delivered. But being recorded is not an essential element of a deed. It's still a deed whether it's recorded or not. But it needs to be recorded. That'll make your brain twist up like a pretzel. Acknowledged, notarized just means a notary public. A person, anybody ever had anything notarized? Basically, you need to sign in front of a disinterested third party who can prove and has signed off with their given seal by the state. Yes, I saw him sign it. Yes, I saw her sign it. That's what notarized means, or acknowledged. And then the exact amount of consideration on that deed we looked at together and any other ones that you might have looked at afterward on your own time. Hint, hint, not a bad idea just to look at a few deeds. You're not going to see the consideration probably. You might see what's called excise tax referred to. And you can kind of do some math and work backwards and figure out if the excise tax was this, since it's based on the sales price, then they must have bought it for this. We'll talk about excise tax in a minute. And then it doesn't have to be sealed. And that just means these days, doesn't mean wax with a ring poking in it. It just means the word seal in parentheses accomplishes the same goal, but it's not necessary. Reminder that the buyer does not sign, only the seller. The buyer is the grantee. The seller is the grantor. The grantee receives that deed. The seller gives. The grantor gives it. And the EE and the OR is a big hint. We're going to see that more throughout the course. Anytime you see OR, think give-or. Be nice if we spelled it G-I-V-O-R. And maybe you should in your mind from here forward through this course. Give-or, the giver, is the OR person. The receiver is the EE person. So when it comes to a deed you're talking about, the one giving is the seller, is the grantor. The one receiving is the buyer, is the grantee. When it's an offer to purchase, the one giving the offer is the offeror. or, meaning the buyer. The one receiving the offer is the seller, the offeree. Now, that flips when that seller decides to counter offer, because that could be a thing. Maybe they didn't like that offer they got from the buyer and they say, well, I don't exactly like that price. Let me change the price. And well, now they've counter offered. Now it's the seller who's the offeror and the buyer receiving that offer, the counter offer. They are the offeree. We'll get a lot more into that in 9 and 10. The lease we'll get into, I think it's 11 and 12. The leaseor is the landlord. The leasee is the tenant. In a mortgage, this one is confusing because if I didn't show you this and I asked you, who's the mortgagor, the lender or the one borrowing the money? I know I would have gotten it wrong. The mortgagor is the one giving the promise to repay the money, which is the borrower. The mortgagor, the giver of the mortgage, you're giving a mortgage to that lender, and that lender now has proof in writing that they have legal permission to take your property from you if you don't hold up your end of the bargain. Does that make sense? Mortgagor is the borrower. The mortgagee is the lender. Make a note here, asterisk, write it in your little journal, because this is an easy one to get wrong, especially when your brain is fatigued. The mortgagor is the borrower because the borrower is giving the mortgage to the lender. The mortgage is a promise to repay. It's basically saying, the mortgage is actually the pledging of the property as collateral. Borrower is saying, here's my property if I don't pay you. That is what the mortgage is. So the mortgagor is the one giving the property in the event of not paying, which is the borrower. An option to purchase is a choice. The seller is giving the choice to the buyer to exercise the option or not. And the buyer has an amount of time, the option period, during which they can decide if they want to buy it or not. The way an option might happen is, let's say you've heard that there's going to be a meeting to change the zoning in an area of the county that you like. And a seller is trying to sell their property in that area or is kind of interested in selling. You approach that seller, you the buyer, and you say, look, if the zoning changes to commercial, I will probably want to buy your property. Right now it's just residential, but if that zoning changes to commercial, then I'm going to want to buy it. But I don't want somebody to come along and steal it from me and get in my way. So let me pay you some money now called an option fee. And in return, you'll give me, let's say, a year to have time for the zoning meetings to happen and that whole process so that we can see if the zoning is indeed going to change. If it changes to commercial, I'll probably exercise my option and go ahead and buy the property from you at this price we'll agree about later. But this just holds my place in line. The seller receives this option fee for giving that buyer the privilege to have an amount of time to make a decision about it later. They're just buying, the buyer's just buying some time with an option to purchase. And so the one giving the option is the seller. The seller is the optionor. And the one who gets to sit back and decide within an amount of time is the optionee. A contract for deed we'll get into some more later too, but that's basically seller financing. Seller financing. Now it's different. Seller's not just selling and giving you the deed. They're going to be around after the sale because they're going to be the bank. You're buying it from them, but you're also not having to pay them all the money at closing because they're going to let you pay them the money in the form of monthly payments as if you were borrowing money from a bank, except the bank is the seller. It's a completely different animal than what we're used to dealing with. In fact, there is no standard offer to purchase and contract for a contract for deed, seller financing. It's not like a standard form that we have access to as brokers. There is a standard offer to purchase and contract. That's what I gave you in your Google Drive. It's called 2T. 2T is the standard offer to purchase. That does not involve seller financing. That is a very unique animal that would require a specifically customized, drawn up contract by an attorney. So when you have a client who comes to you and says, I want to buy this property with a seller financing in place, you say, okay, let's talk to an attorney and get them to draw it up, because I don't have a form I can just pull off the shelf and fill in blanks for. It needs to be customized, because now we're talking about, at what interest rate will you be borrowing this money from this seller? At what interest rate will the payment be calculated? And how many payments will there be? And are we talking a 10-year amount of time to pay them everything, or 20 or 30? There's a term, there's a rate, there's a payment. All that stuff needs to be put in there. So a contract for deed has completely unrelated looking words. When it's the one giving the contract for deed, it's the seller. That's the vendor. The vendor. The buyer's the vendee. Contract for deed. Vendor and vendee. Okay. What are these things, deeds, we speak of? The deed is basically the title to the property. We want to buy from a seller that can give us assurance that they really are the seller, that they really own it, and if there's any dispute or problem down the road, that seller will back it up. Isn't it better and more comforting as a buyer to buy something with a warranty built in? It's nice to buy on eBay and Craigslist because it's cheaper, but if I buy a guitar that's used on Craigslist for $800 and I can buy a new one from Guitar Center for $900, I'll gladly pay an extra $100 because at Guitar Center they give me a warranty, a guarantee. If I don't like it, if it's broken, I have at least 30 or 45 days to take it back. They'll stand behind it. That Craigslist guy is gone the minute you drive out of the Walmart parking lot. It might have even been a stolen item, right? That's just the downside of it. But the upside is probably for cheaper. So it's not enough. I would want to maybe buy that guitar for $400 instead of $1,000 to make it worth giving up this security blanket of a warranty. When it comes to a deed, the amount of guarantee, the amount of backing it up is known as a general warranty deed. That's the best kind of deed. It has a guarantee, a defense by the seller, defending the title against all claims against the title forever. That seems kind of ambitious. How's that seller going to guarantee this title forever? Well, while they owned it, they had title insurance. And that title insurance company, in order to issue that policy, which we'll learn about momentarily, did some research. The attorney did research to see, are there any problems with this title? They'll check it for liens. They'll check it for other people who have put a cloud on it, encumbrances. That's why you should have a survey, so your title insurance is more comprehensive. So that general warranty deed gives you 5 covenants, 5 guarantees. As I try to find the page. Here we go. It's on page 77, 78 of your book. Okay. So it's got 5 of them. The special warranty deed is only 2 of those 5. We'll dig into them in a moment. The grantor is defending the period of time that they own the property. See, the general warranty deed up there, that seller is saying, yeah, I'll defend the title forever against all claims forever. If that seller cannot do that and all they can offer is a special warranty deed, they're just saying, look, all I know is that while I owned it, there weren't any problems. And I will attest to that. I will guarantee and defend the title to my property for the amount of time that I was the owner of my property. But I'm not guaranteeing it for the person before me. It's just for while I owned it. It's 2 out of the 5 guarantees that we'll see in a moment. And then a quit claim deed is another way that you could get a deed. It's also known as a bargain and sale deed. There is no warranty provided to the grantee at all. I'll sign the deed over to you, but I'm not standing behind it. I'm the seller. I'm not defending it at all. But I do own it. I'll sign it over to you. no warranty provided to the buyer, borrower, grantee whatsoever. This general warranty deed covers the past, the present, and the future. That's the best one. If you're a buyer, you want to buy a property from a seller giving you a general warranty deed, but it doesn't mean that you'll choose not to buy it if they can't give you this general warranty deed. Because one very common situation where you could buy a property that does not give you a general warranty deed, but only a special warranty deed, is when you buy a foreclosure. Because think about this. The bank has taken that property back from the previous person. They foreclosed on the property. They took it from that borrower who didn't make their payments. They've got this. They own real estate. Banks don't like to own real estate. They like to loan money out. They want money liquid. They don't want it tied up in property. So they want to get that thing sold to get the cash in hand so now they can loan it out to someone else. When a bank owns real estate, it's literally called what? Anybody know? What is that property that banks own called? That thing. REO property. Real estate owned by a bank. REO property is bank owned real estate. And they sell these because they want it turned into cash. Because they can't loan out based on houses. They want to loan out the money, the cash, to make that interest. It's all about that interest for that bank. So, if a bank has taken back a property from someone, they weren't the owner for the entire time that person they took it from was. They're not going to give you a disclosure about the property either. They're not going to tell you anything. They don't have to. There are an exemption to the disclosure rules, by the way, because they weren't there. They don't know. And they sure as heck aren't going to make any guarantees or promises about it, except when it comes to this deed. What they will guarantee is just the amount of time they owned it. It might have just been the last year, because by the time when they take the property back from a borrower, it's probably going to take them about a year. This is not on the test. This is just real world information. Probably not going to be able to buy that REO property until 9 months to 12 months after it's taken from the previous person. It takes the bank that long to get their ducks in a row, to get it squared away. Maybe they're going to clean it, empty out the trash, get an agent, one of their go-to agents to, by the way, if you can get signed on with the bank as their go-to listing agent, and that's what you do is list their REO properties. A lot of agents who specialized in that did really well in 2008, 9, 10, 11, 12. But you've got to kind of, work for that one entity and really cater to them. And there's a lot of people fighting for that business. So if you're lucky enough to get a foothold with a bank to be their go-to for their REO property, do it. As long as that's in your skill set and the way you like to do things, because you do have to kind of prioritize them. Okay, back to this general warranty deed. This is for the case where people have owned it for a while. They say, look, I have no trouble backing this up. I'll guarantee it from the past because I did a title search when I bought it, and I'm confident that that was accurate. And then there was no problems back then that I've inherited and that I will give to you. You're good. And my present situation is still good. No problems, no crazy cousins that are coming in saying they own some of it, no liens, no issues. And then I guarantee, therefore, because the past is good and clear and the future and the present is good, that the future will be no problem for you. So when you close, when you buy my property, I guarantee you're going to be okay when it comes to the title because it's been clear so far. What are those guarantees? Page 78 of your book, a general warranty deed, 5 covenants. A grantor, the seller, can convey seisen. Oh no. Another one of those darn legal type words. We're so tired of those words. This concept of seisen kind of comes from sort of a medieval, Middle Ages concept time. Think of somebody from back in the day like Robin Hood, and you're looking out over the rolling hills before you, and you're talking to your buyer that wants to buy your acreage, and you say, see all of that? See from where we're standing to the trees in the distance? That is all mine, and that is all what I'm selling to you. It's sort of acknowledging this is what I'm conveying to you as the seller, as the grantor. That's all it is. That's what seisen is kind of talking about. And in your book, let's see if I can zoom in here. It's just the wording. Grantor covenants that they are seized of said premises in fee. Oh boy. In fee. Fee simple. Is it fee simple? Absolute, determinable, it doesn't matter, but some sort of fee ownership. The covenant provides an assurance to the grantees that the grantor holds the title that they specify. They really are the owner. And the seller grantor promises the grantee that they have fee simple title to the property. This is mine. This is what I'm selling to you. And it's free from anything that I know about. I don't know about any liens that are on this property. It's free from encumbrances. I guarantee you that. That's in your book. Oh, sorry, it's not quite. Oh, it's on my hand. There it is. Covenant against encumbrances there at the top. And then here's what it looks like on the slide. Grantor can convey Sizen, their ownership of it, free of any liens, encumbrances, protected from any third parties. That's all that quiet enjoyment means. It doesn't mean you have to keep the music down. It means no third parties are going to come. And if they do, I'll guarantee and I'll protect you from them because I'm giving you this general warranty deed. Quiet enjoyment. You can enjoy it from the peskiness of some jerk coming along saying that they own it, because they don't, because I'm the only one. And further assurance, covenant of further assurance says, I'll back it up. I'll help you if you do have trouble in the future. I'll help you track down information to clear anything up that might pop up randomly in the future. Not that it would, or it probably won't. But if it does, I'm still going to guarantee that. And forever, even after the sale. How can they do that? Because probably they had title insurance, and that insurance policy has been granted to that seller while they owned it to protect the title. And so you better believe that title insurance company felt confident in the title being good and clear and clean. So therefore, the seller, grantor, can feel confident in conveying it and warrantying it to the future owners. Special warranty deed, again, is only for the time of ownership. It's limited. Not as good as a general warranty deed, but it's still okay. You can do it. And if your buyer is going to be buying a bank foreclosure, they better be okay with it because it's probably the only option. The bank is rarely, if ever, never that I know of, going to give a general warranty deed for an REO property. It's only for the time of ownership, probably from a bank foreclosure. A quitclaim deed, and now, we're on page 80 in your book. There it is. There's no guarantees. There may or may not have a claim to the title, but I'll sign it over to you, and it's your problem. It's usually used when they need to clear up some sort of an error. Quitclaim deed is usually to clear up some sort of an error. Bargain and sale deed gives no guarantees, and it does have claim to the title. It's to clear up a cloud. And it's this idea, you can see the wedding rings clashing in this dramatic graphic right here. It's a divorce. Bargain and sale deed, one of the parties is going to get the property in the divorce. They're going to sign. The one giving, maybe buying their part out and giving it to the other, is the grantor, and the other receiving the property is the grantee. I'm going to use a bargain and sale deed to hand over the property to the spouse getting it in the divorce. That's a good idea, Twee. That would be a good use of a quitclaim deed in the chat. So there's some other kinds of deeds. A correction deed is like typos. Just hey, we need to correct this deed. It had a swap of some words, and I saw one. Gosh, it's been a few years now, but I forgot. What was it? Gosh. The name, it was the street address. It was one of those 3 or 4 named kinds of streets, and they had them swapped. Like Forest Ridge Road, it was Ridge Forest Road. I just made that up. But at that level of a mistake, you would use a correction deed to clear that up. In fact, now that I think about it, it was on the deed that was from the seller, and I was the buyer agent. And I said, that deed that we're getting has a mistake. That's not the actual address, and that's the deed they had the whole time they owned it. So I just called the attention of it to that closing attorney, and they fixed it so that my buyer would have it correctly worded. A gift deed, this is important. If somebody gives you a property with a gift deed, you better say thank you, and you better hurry up and record it within 2 years, or you don't have it anymore. So if you get the gift, go ahead and record that thing so you can keep the gifted property. A release deed is also fun and happy because that's what you get when the mortgage company says, I'm acknowledging that you've paid me the entire loan balance plus interest, and you get to burn your mortgage because it's all over with. You don't owe me anymore. It's your property, free and clear. There's no mortgage. So a release deed shows that the mortgage has been paid off. There's some court-ordered deeds, and this is all kind of level 1 stuff, guys. Don't get too caught up in the details of this. Is just other kinds of deeds. If the court is involved, there could be a trustee's deed, a sheriff's deed, a tax deed. Different jurisdictions call them maybe different things, but they're all kind of related to liens against the property, foreclosure situation, that type of thing. So court ordered involves the words like trustee, sheriff's, and tax deed. Those are all things the court could have a say in and say, hey, we need to have this deed signed because of this lien, because of this situation. They're all special of some sort. So give me 3 types of deeds that a grantor might use. Just name 3 of those last 5 or 7 deeds we just talked about. Tell me in the chat. General, yeah, there we go. Special, gonna let Twee do all the heavy lifting. There we go. Quick claim, okay. Sheriffs, trustees. Yeah. And then the term used if someone dies without a will. What's that thing called when someone dies without a will? Intestate. Good job. And who gets the stuff if the person dies without a will, also called intestate, and no heirs? The state. Yeah. Intestate goes into the state. Oh, sorry. Dad humor. Dad reference. I'm a dog dad. I guess that counts. Okay, some math. Math. You say that like it's fun. Excise tax. And forgive me in advance because I am old in the business, old school. I will probably call this revenue stamps at least once accidentally by the time we're done, because that's what we used to call it. Revenue stamps. Literally, revenue meaning tax. Stamps, the way they used to do it was they would take the deed to the courthouse to record it. The person at the counter would say, okay, give me the tax amount, give me the dollars of tax you owe. And she would take the tax stamps, lick them, stick them on the deed. It would literally be stamps on the deed reflecting that the excise tax has been paid. But we don't call it revenue stamps anymore. It's called excise tax because that's the dollar amount. When a seller sells property, they get to pay a tax for the privilege of having sold their property. That's the way I explain it to sellers at the listing appointment usually. And it's just a government required tax based on a dollar amount. It's based on the sales price. Excise tax is a tax based on the sales price. Think of it like a sales tax, right? So you might see it referred to as deed stamps, revenue stamps, tax stamps. And here's the formula. For every $500 of whatever the sales price is, you have to pay it $1 in tax. For every $500 of whatever it sells for, you have to pay $500 or $1. So basically, you take that sales price. Let me pull up my calculator. There we go. Property sells for a sales price of $150,000. What is the excise tax? It would look as simple as that. Or what is the amount in excise tax that the seller must pay? Take that 150 sales price, divide it by 500. That's it. You're done. $300. Seller gets to pay $300 if they sell the property for $150,000. So if they sell the property for $150,000 and they don't owe anybody anything, they don't owe a mortgage balance, they don't have to pay any commission, they're at least going to have to pay excise tax. They're not getting $150,000, they're getting $149,700. Now, they're having to pay many more things than just the $300, but that's the formula. Now, here's where it gets a little more complicated. What if the sales price is this? $150,300. Sales price is $150,300. Oh my gosh, this survey for this calculator. I just got to buy this thing. Okay, 150, 300. Divide that by 500. Oh, that's a excise tax of $300.60. Here's the thing. The government doesn't want your change. They do not want 60 cents from you. Round up to the nearest dollar. Your excise tax will never be in 60 cents. It'll be $301. So you just do the calculation, and if it has cents, round up to the next dollar. That's it. That's all you have to do. But there's a couple of ways to do it. I like this way because it's straightforward. You take the number, you divide it by 500. Oh, there's some change. Then let's go up to the next dollar. Done. But it could also look like this. You could choose, look at the one on the left. They're saying to you, 152.2 is the sale price. You could just round that $200 up to the next 500 increment. So round the 152,200 up to 152,500, and then do that calculation. 152.5 divided by 500 gives you in this case, $305. Versus the thing on the left is what I showed you. Just divide whatever the sales price is by 500 and then round the resulting, in this case, $304.40 up to the next dollar. Do you like A or B? Do you like left or right better? Doesn't matter. Whichever one naturally comes to your mind is the one you should do. Just like we'll learn this in the other calculations. There will be many ways to do a thing. Like last week, I think somebody, it might have been Jennifer, somebody said, do I have to divide by 100 on the rate, or can I just divide the entire bottom of the thing? In that case, mathematically, it doesn't matter. So do you. That's fine. But if it helps you remember it better, properly is to divide the actual rate, $1.15 per 100, divide $1.15 by 100, and then multiply that by the tax value. In this case, whichever one just hits your memory and sits there better and pops to mind in the moment. Because always think about this when you're doing this studying. How am I going to handle this when I'm tired? 2 hours into the test. Do it the way that comes easier for you in moments of fatigue, right? I seem to like the right side way better. So look at this one. A property sold for $675,300. Buyer purchased it with a loan in the amount of $540,000. How much will North Carolina charge the buyer for excise tax? How much is that buyer going to have to pay for excise tax? Tell me in the chat. Since you're muted, you are free to call me dirty names, mean names. That's okay, because I played a mean trick on you just now. It's okay. I just slid that in there like we were talking about buyers this whole time. The buyer doesn't pay excise tax. That's a common test issue. Be careful. Make sure you know who's paying it. You'll have to know who's paying these various numbers when we're doing calculations. It's the seller that pays excise tax. It's a sales tax the seller has to pay. Now, when you go to the restaurant, the buyer who's eating at the restaurant has to pay the sales tax. But when it comes to this real estate excise tax, seller pays the excise tax for your purposes in this class. In our standard offer to purchase, that 2T document that I gave you in the Google Drive, it is written in there that the seller is responsible for excise tax. But it is not a rule or a law. It is just a, what is it? It's a, gosh, I lost my word. It's just the way it kind of is. It's negotiable, actually. And if you go to a new construction community, when you take your buyer to a new construction community and you read through that contract that they have to sign to buy a new home, by the way, a new builder's contract is way bigger, many more pages than our standard contract. Our standard one, the 2T, as you'll see when you look at it, 15 pages. A builder's contract is at least twice that, because that builder hired an attorney to draw up the contract to favor them, the builder. That builder wants that contract to be in their favor more so than the buyer. The 2T one that I'm sharing with you, that was prepared by the Realtor Association, and it's more balanced to benefit both buyer and seller equally. So the standard of practice through 2T is that the seller pays excise tax, and that's what you need to know for this class. If the test question says who's responsible for paying excise tax, your answer is seller. But out in the real world, your answer is, I don't know, I haven't seen the contract yet. If it's new construction, guess what? That builder had their attorney put that excise tax responsibility over onto the buyer side because they could. It's not illegal. The buyer has to agree to it if they want to buy that house. Or they could try to negotiate and say, I don't want to pay those excise taxes. You pay them. Good luck with that. Then it's just a matter of, will that builder negotiate it? But again, for your purposes, seller pays excise tax. So how much will North Carolina charge the seller for these? You've already given it to me. We've got $675, $300. Oops, 75, 3. I'm going to divide it by 500. And oops, it gave us a pesky decimal, gave us 60 cents again. We're going to increase. We're going to round that up. $1,351. Good job. $1,351 is the excise tax. Now, what about this 540? What are they even talking about? We didn't talk about the loan amount. Oh, that's with the 1080. Yeah, see, here's a classic example of they gave you more information than you needed. We do not need to know what the loan amount is in order to calculate excise tax because it's just based on the sales price. So watch out for that. Watch out for too much information. I see our time. I know it's about time for a break. Good time to do so because we're going to get into title insurance, title assurance, and that whole process. So let's come back at 11:10. 11:10. How are we sure that this title is nice and clear and good? Assurance of title involves insurance of title. So this title assurance process involves the attorney examining it. The attorney will look back at public records, check recordings, look at lien priorities if there are any liens. They're going to examine this property title and go back to see previous owners. They want to see, who did this current owner buy it from? And did they buy it from them with no problems? Or were there issues? And did they clear up those issues, or are they outstanding? So it starts with the attorney. The attorney is going to look at the chain of title. They have a database, just like our multiple listing service tracks properties that have sold. The chain of title It's called a grantor grantee index. And it's something that the attorney subscribes to so that they can check and say, oh, this is Tom Jones and he's selling the property to Brian May. And Tom looks like 10 years ago bought it from Freddie Mercury. And then 2 years before that, Freddie Mercury bought it from Stevie Ray Vaughan. And they'll go back through time and see through this grantor grantee index who bought from whom. And then once they're satisfied, the closing attorney is who we're talking about, they're going to issue an opinion of the title. And they're going to say, the best I can tell, you're in good shape. It's a clear line from whom this seller got the property and who they got it from and who they got it from. Nice, clear chain of title. Then that attorney is going to say to the title insurance company, they're going to say to them, look, I've checked the title. It is my opinion that it is in good shape. You are free and clear to issue a title insurance policy with no trouble. And as long as that title insurance company agrees and everybody is okay, the title insurance is going to be recorded and we have coverage. You might see this term on the national section of the exam, something referred to as an abstract of title. That is just a very, very extremely detailed chronological history of events of the title. We don't do it that way in North Carolina very much, if at all, but some states require it. So abstract of title could be something you see on the national. Purpose of title insurance is to protect the lender and the buyer from any financial loss because of some sort of a defect in the title, like an encumbrance, an encroachment, a lien, another party coming out of the woodwork claiming ownership. And so if you're borrowing 90% of the value of the property, as is often the case, many times the loan amount that you're borrowing from a bank to buy it is like a 90% of the value loan amount. It's a lot. You're borrowing almost the entire amount. And if it's a VA loan, it's probably the entire amount. That lender has a lot of money at stake. You better believe that lender wants to be named on the title insurance policy. They have their very own, in fact. So when you buy property that is going to be financed, the title insurance policy, there needs to be two of them. There is a lender's policy, and all that lender is worried about protecting is the amount they're loaning you, the amount they're loaning that borrower. If they're only loaning the borrower $300,000 at the purchase price is $600,000, they don't need coverage for $600,000 worth. They're just worried about the $300,000. So the lender's title insurance policy is going to cover the amount of the loan. What happens to that loan over time?
Mr. Neal,
Yes.
I'm currently going through that right now. Me and my brother are purchasing a commercial property, and they are requiring both of those, the owner and the lender, but it's right over the 600,000 that you're saying. So they pretty much not even worried about that at all. They just want to cover only 300,000 of their loan.
The lender wants a title policy for the loan amount, but the owner is probably going to want the title policy to cover the full value, right? Because here's the next thing. The lender's policy is going to go down over time, like every month. They don't need coverage on, in this case, 300,000, because next month you don't owe them 300,000 anymore. You made a payment. You owe them 300,000 minus like whatever your payment was, the interest of it, right? You're paying that loan down. So over time, that lender's policy amount decreases until finally in 30 years or however long the loan term is, there's no need for a lender's policy anymore. And at which point it'll be gone. It'll be canceled because the lender's gone. You paid him everything. So the lender's policy, here's the testable part. Lender's policy is in the amount of the loan balance, which decreases over time. The owner's title insurance policy needs to be for the value of the property. It'll be for the sale price. So it'll cover their full value. Because that owner's title policy, they're going to want to hang on to that. Once the lender is all paid off and gone, there's no need for a lender's policy, but that owner still wants a policy in place. Now, the good news about the title insurance is that it's a one-time fee. You pay for it when you buy it. It's not a monthly fee. You don't add that to your principal and interest and your taxes and insurance house payment. It's just I paid it at purchase, at closing. It covers you forever. You're good. So it's a pretty good deal. And it's not that expensive.
Does the buyer normally pay for the lender's policy?
Great point. And that's a good rule of thumb. When it comes to that closing math we're going to look at, and the buyer is borrowing money, anything the lender requires, the buyer is paying for, right? Because they need the money, because they're the reason they're borrowing money, and that lender is gracious enough to loan it to them. Therefore, any lender required fee is covered by the buyer. So that buyer pays for both of these. Another testable question, by the way. So good foresight there. And so we could look at it this way. Title insurance is the best title assurance. The best way to assure your title is nice and clear and clean and clear is to have title insurance. If you're buying the property with a loan, the lender's going to require title insurance. But if you're paying cash and there's no lender, you could choose to not get it. It's a terrible idea, but you could. So the best title insurance is best title assurance is title insurance. It's paid one time, paid by the buyer, both for the lender policy and the buyer's own policy. And then the owner's policy is for the value of the property that stays consistent over time. The lender's policy coverage is for the loan amount. And since the loan amount goes down over time, the lender's title insurance policy amount coverage goes down to match the loan amount for whatever it is in the course of time. Okay, shifting gears a little bit. That was title insurance. Documents that should be recorded, not required, but they should be, are these. The thing I'm talking about here is the Connor Act. The Connor Act says, in order to protect against third-party claims, against some third-party Yahoo coming in and saying, hey, I own this thing. In order to protect against that, you need to record a document. The document in question needs to be recorded to protect against third-party claims. Think about, just recite that to yourself. To protect against third-party claims, it must be recorded. Documents should be recorded. What documents should be recorded under the Connor Act to protect against these third-party claims? It's this acronym. Makes no sense. It has nothing to do with the topic. It's just words that you might already know that might help you spur your memory. Dream Oil. Dream Oil. What documents should be recorded under the Connor Act to protect against third-party claims? Deeds. We already looked at that one. Also, restrictive covenants. If you're a seller and you want to sell property and make like a subdivision and sell it like it's just big enough for 10 properties, and you say, this is my family land, I am selling out, I want to take the money and run, but I do want it to be nice. I don't want it to ever kind of fall into this ugly kind of area or blight on the area. I want certain minimum standards, and whatever is important to them, let's say what's important to them, I want it to at least be brick houses only. Here's a restrictive covenant. If you buy and have a lot in this neighborhood that I've established, you've got to build full brick house. Or maybe they also feel a certain affinity toward mobility challenged or elderly people. And so they say, we also want it only to be for single level homes. So basic standard, if you build in here, buy in here, build in here, it's going to be brick houses, full brick, single level only. And you name it. Could be other restricted covenants. They need to record that list of restrictive covenants so as to protect against any sort of third-party claims under the Connor Act. Also, easements, assignments. We'll talk about that. I'll come back to that. Mortgages should be recorded. Options to purchase. We talked about that earlier. Installment land contract, seller financing. And then let me come back to this lease one. Let's talk about assignments. An assignment. Has anybody seen a yellow sign on the side of the road, handwritten? It says, we'll buy homes for cash. They're called bandit signs, right? And it's an investor looking to find a desperate seller. That's really what they're looking for. They want to find an opportunity because they don't want to pay the market value of $350,000 for that property because that's what it's worth. That's what a typical owner occupant would be willing to pay. They want to buy it for like $200,000 or less. They have a certain steep discount they're looking for, and they're looking for a motivated seller. Maybe someone behind on their mortgage payments, someone with a bunch of tax liens, someone who needs to sell. Sometimes sellers will say to us, I don't really need to sell. I just want to see what I could get. That is not the seller for an investor in this situation. So a lot of times, if you take an investment course, or you'll see the bullet point on the sales letter, if you're thinking about an investment course, they'll say things like this. I'll teach you how to buy real estate without having to actually own the real estate. I'll teach you how to make money in real estate without actually having to close on it. And you're like, what kind of scam is this? It's an assignment, and it's not a scam necessarily. It could be handled that way, but it's legal. An assignment is just this. You put out the bandit sign. You in some way run across a motivated seller, and you've got them under contract. You get them to sign a contract agreeing to sell this $400,000 house to you. In your research, you've determined its worth on the open market, normal sale, non-distress sale, $400,000. But you somehow negotiate with that seller to buy it for $200,000. You're pretty happy. You've got it in writing that they're going to sell that property to you for half of what it's worth. Only problem is you can't afford it, because all you're really trying to do is lock somebody down to having to sell their property at a steep discount. What you're going to now do is get on the phone and call your investor friends who can afford it and say, look, I got one for you. If you pay me $10,000 right now, I'll assign this contract over to you. You go show up at the closing and you buy it for $200,000. And they'll say, wait a minute, it's really worth $400,000 and you got it locked in for $200,000. And they'll verify that and they'll say, oh, okay, great. Here's your money. As long as what it's going to cost to repair it all fits and the numbers work. If it's going to cost another $400,000 to repair it, we don't have a good deal at all. But if it's going to be $50,000 to repair it plus $10,000 to you as a bird dog kind of a thing, they're still good. They still have room in the deal to have gotten a good price for something that is now ready to be sold for $400,000. Maybe they're all in. They paid to fix it up, and now all of their money between buying it and fixing it up is like $300,000. They have a $400,000 property. They have $100,000 of equity in this property. That might not even be good enough for some investors, by the way. But that's what we're talking about. It's an investor or somebody. It's a buyer under contract who sells their contract to another person or entity for that matter. They assign it to someone else in exchange for probably money. So an assignment is just assigning over. Now that standard offer to purchase and contract called 2T that I've given you, that we use most of the time, it allows for assignments, but it specifically says the seller must be made aware that you're assigning it. Can't assign it without the seller's permission and awareness and disclosure.
Is that the same as like a wholesaler with
Yeah.
a double close?
Yes, sure is. They do not need a real estate license because it's their own property. They have contracted, they're under contract to be the buyer. So they own this contract. They are the buyer. They're not doing it for another buyer. In that case, they would need the license, Jennifer. But in this case, they are the buyer, but they're selling their rights as a buyer to another. They're assigning it to another person. So that needs to be recorded in order to protect against third-party claims under the Connor Act. Okay, this last one, leases for more than 3 years. That sounds really weird. And so the way it works is this. It's think more like a commercial lease. More than 3, not 3 or more either, by the way. More than 3 years need to be recorded to protect against third-party claims. So think about a tenant leasing a property and the property owner, they've signed a lease for, let's say, what's 3 years, 36 months. They've signed a lease for 37 months, not 3 or more years, more than 3 years. They've signed that lease. The property owner, their landlord, sells to someone else, and that new owner says, you know what? I don't want to do this anymore. You're out of here. That tenant could be in a situation where they have to leave because their lease is for more than 3 years. They need to have it recorded to protect them from getting booted out. If it's 3 years or less, that's built-in automatic protection. There's landlord-tenant laws that won't let them get pushed out. The new owner has to honor existing leases, but more than 3 years is required to be recorded to protect them. I know it's a weird little nuance, and we'll get more into it when we get into the leasehold estates, but that's what it means. Leases for more than 3 years. What to look out for on the test question? If they say such and such is under a lease for 3 years and blah, 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 and their lease is not recorded, and that should trigger a flag in your head. Oh, wait, 3 years, that's not the thing. It's more than 3 years that matters for this leases situation under the Connor Act. So Dream Oil, add that to your acronyms list. We talked about the race to the courthouse. If the purchaser, and I gave an actual example, I forgot who the victims were here in the class, but somebody went ahead and had lunch. I think it might have been Janina, had lunch. Instead of going to the courthouse to record the deed that I just signed over to her, she had a celebratory lunch. In the meantime, I believe it was Jennifer who remembered what we learned in class. She went straight to the courthouse and recorded. And even though the date was earlier on Janina's, she didn't get there before Jennifer. Jennifer recorded first. Janina finally got there and found out, oh, somebody's messing up the chain of title. It says Neal went to Jennifer, and Jennifer's now the owner. The deed that I've got, Janina's saying this, the deed that Janina's got says that she's buying it from Neal, not from Jennifer. Therefore, not going to work. That chain of title thing, broken. She's now going to hire Dog the Bounty Hunter, and I'm going to be in trouble when he finds me, right? So she's going to have to take it up with me. It's my issue because I did the wrong thing here. She just didn't get to the courthouse in time. If she had beaten Jennifer, now it's Jennifer who's mad at me, right? So it doesn't matter when I signed the deed over to which of those two. It matters which of those two got to the courthouse and recorded it first. And that's what this whole one slide means. Whoever records first owns the property. Now, in real life, it's not that dramatic. That's part of the whole reason that the process is the way it is with a closing attorney. We don't have, first of all, a seller would be crazy to sell the same property to two different people. There's like major legal issues there. But the attorney is handling all this stuff. They're recording the deed, and they would have found that another person has come forward, and that's part of the process. When they get there to record the deed, they're going to see, okay, is the owner of record still the seller that I have on this contract? It is? Okay, great. We're good. Oh, wait, no? I've got a contract that says this buyer is going to buy from Joe Blow, but what I've got now that I've checked one more time at the last minute here before I record this deed, it's looking like the seller's not Joe Blow. It's in fact John Doe. Oh, I've got an issue. Contract seller doesn't match the current owner in the system seller. So that would be what reveals the issue at that point. Recording documents puts them on the public record. Somebody asked a great question on Notion. That was part of what I addressed in that Q&A video, which was, what is this thing about the contract not being recorded, but the deed has to be recorded? And in the answer, it's this. We don't need all the details of a contract to be on public record. All that matters is who owns it now. Doesn't matter that they paid $3,000 in closing costs and the refrigerator was included and the patio furniture too, and they closed on December 11th. None of that is needed. All that's important for public record is who is the owner. So that's why the deed is what needs to be recorded and not the contract. But that's a great question because I had led with this little statement. I said, which is more important? And we learned that the contract is considered more important than the deed because it's from the deed. The deed gets filled out and created by the attorney based on what they learn from the contract. Recording something puts it on public record. The legal term is called constructive notice. The information is available to everybody. An actual notice means information has been given. It's actually out there. It also serves to establish that priority. Who recorded something first? This is on the record. Someone else comes along. Well, did you record it? No. Oh, well, then you've got a problem, right? Who gets paid first? Who owns the property? You've established it in the public record. And then it also, as we saw with the Connor Act, protects against third parties. This is mine. It's recorded. I have proof. Go look at the courthouse records. You don't have to physically go. You can probably log in online. Most courthouses have their Register of Deeds information online available now these days. That's nice. I've had to go to the courthouse before and walk into the dusty library and look for the books. It's a bunch of shelves full of huge, weirdly shaped black books, and you flip them open, and they weigh 1,000,000 pounds, and you find the right page for the poorly copied deed, and it's hard to read. The recordation happens physically at the Register of Deeds in the county where the property is located. Probably available online too, but it does have a physical existence. So remember, a deed is still considered valid, still legal, even if it's not been recorded. But in order to be considered having been delivered and accepted, sorry, not delivered, but accepted, it needs to be recorded. Also, in order for the buyer to get the keys and the seller to get their sales proceeds, it needs to be recorded. And for you to get paid too, by the way, from a closing. When it comes to that title search thing, the attorney is doing that title search, the grantor grantee index. They're looking back at that chain of title. They want to see this seller sold it to this buyer, and now this buyer is the seller who sold it to this next buyer, and on down the line. They do not have, some properties have been around for a long, long time. I once met a group of guys from like Scotland and in England. We did a job together. We both worked the World's Strongest Man event in 2011. I got to set up some of the big crazy displays and meet some of those guys. And like the Mountain from Game of Thrones, I have a picture with him. Met all those guys. And so what some of the worker people said to me when we would go to lunch, it was about a 3-week period of time. They said, why does no one have a proper roof in this area? They were looking around at these asphalt roofs. They're used to seeing slate, like real substantial roofs, because over there, 100 years is like nothing. Houses are 100 years old, and that's just normal. Here, good luck with a 100-year-old house built to the standards we build them these days, right? And over here, by the way, they say over there, 100 years is nothing. Over here, 100 miles is nothing. 100 miles of distance versus 100 miles of distance over there. So this 30 years back, you don't have to go more than 30 years back, is what the Marketable Title Act says. That attorney, when they're doing their title search to satisfy the title insurance company, they're only looking back. They're only required to go back 30 years. If 31 or more years back, there's some sort of issue, doesn't matter. It is quieted. It is a non-issue as per the Marketable Title Act. Anything that went down more than 30 years ago, irrelevant. So they only need to search back 30 years. So as long as there haven't been any serious defects, significant liens, questions of law, exposure to any sort of litigation, a threat to quiet enjoyment from a third party, as long as all that has been the case for the previous 30 years, that attorney is going to tell the insurance company you are okay. It is safe to issue a policy. Everything looks nice and clear. Any prior clouds beyond the 30-year mark are extinguished because it's 30 years, because it's more than 30 years. That's what the Marketable Title Act says. The attorney only needs to search back 30 years. No more than that. Any problems beyond that, extinguished. Things that are not recorded, contracts are not recorded. Promissory notes we'll learn more about in Chapter 9 are not recorded. That's the outline of the loan terms. The promissory note is what you promise to do. It says you're going to borrow this amount for that interest rate. The payment's going to be that amount. It's what you give the lender to prove that you are agreeing to pay them in installments later. Also, agency agreements, 7 and 8, chapter 7 and 8, when we're dealing with sellers and buyers, we get that in writing. Why do we get a listing agreement, by the way, as a broker? Why do I want a listing agreement signed by my seller? Who's that benefiting? Me. I want it. The seller would just be fine without having that. Oh, okay, I'll let her try to sell my property without in writing because maybe next week I want to not use her anymore. But you, the broker, are like, nope, not spending $1,000 to take aerial photos and fancy professional photography and a professional measurer to draw me a floor plan and commit to some Facebook ads and this and that. There's a lot of front end expense in a listing. Doesn't have to be, but depends on how competitive the market is. So are you as a broker willing to put out all of that if you don't have it in writing? No. In fact, the real estate commission won't let you do any marketing activity without it in writing. The listing agreement has to be in writing before you do any listing activity. But they don't need to be recorded. Agency agreements, that would include listing agreements with a seller and buyer agreements with a buyer. Buyer agency agreements, listing agreements, tenant, landlord, property management. There's lots of different kinds of agency agreements. None of them need to be recorded. And it's not one of those things where it doesn't require to be, but it should be. They're just not. You don't record them. So what are those two types of transfer of title? There's the happy kind and the sad kind. What are they called? What's the proper terms for the two methods of title transfer? Kind where we're willing and happy about it. And then there it is. Yeah. Involuntary. We're not too thrilled about that one. Voluntary and involuntary. You got it. Why would a buyer be advised to get title insurance? We didn't really come right out and say this one, so you're going to have to think about this one. We talked about the process that here's how it goes. Here's how we get it. Yeah, there you go. To protect the purchase. The thing is, here it is. Especially if that grantor, that seller gives a general warranty deed, well, a person given a warranty, you're only as good as the person can stand behind it. What if everything goes crazy sideways and you do have to go find that grantor, and when you find them, they're either dead or insolvent. Insolvent means broke. They can't. They feel bad. They would. Maybe they said, oh gosh, I would if I could, but gosh, I don't really even have the money for my rent. If the grantor does not have money to reimburse you for the losses that they've given you a general warranty deed 10 years ago when you bought it, but somehow something went weird and something came about, you track down that grantor and they don't have any money. They legitimately can't afford it. The title policy does. The title policy is in place. So why would a buyer be well advised to obtain title insurance? Because that grantor may not be able to reimburse them for losses if they were to have occurred. Side note, in 26 years, knock on wood, got a nice wood desk here. No issues here. Never had this pop up. I don't think it's something hugely common. But you learn a lot of things about what could happen in this class. If multiple deeds exist, how does the court decide who has a claim to the property? If there are multiple deeds, how does the court decide who wins? There it is. Whoever recorded first is protected against the claims of third parties. What is it called? Recording something to protect against third-party claims is called what? What is that called? Highly testable. Huge. What's that little bit of legislation called? It's an act. What is the act called? Connor Act. There it is. The Connor Act says must be recorded to protect against third-party claims. Burn it in your memory. That is almost a guaranteed question. I'd be shocked if it weren't on there. Are we okay? Okay, good. Because we're going to talk about some of this. Oh boy. It's not bad. I always say that. Think it and it shall be. I'm going to talk about a little bit of conversion, a little bit of math going from acreage to square footage, cost of acres. Do you think that's important? Do we really talk about dollars per acre in real life in the wild? Yes. Yes. This is real math. All of the math is actual important math that's done. Now, to be fair, a lot of the closing cost math, like things that we haven't learned yet, like setting up escrow accounts and interim interest and all that, you do need to know how to do that. But in real life, the paralegal calculates that. You just need to be able to check their math, verify that they did it, but you don't have to actually calculate it and plug it into the settlement statement. So that kind of math in real life, you are not like responsible for in terms of calculating. You're responsible for checking behind somebody else. This kind of math is just sort of day to day. This is the kind of math that you're just kind of need to have a pretty good familiarity with just to exist. So it is real. We learned how many square feet are in an acre. There's a whole bunch of them, thousands and thousands. How many square feet are in 1 acre? There it is. Another thing to burn into your memory, 43,560. And the way I remember it, you remember the little old ladies? 4 little old ladies in a little car driving 35 miles an hour in a 60-mile-an-hour zone. You also might remember it with the number 711, because 4 plus 3 equals 7, and 5 plus 6 plus 0 equals 11, and that's 711. I kind of like the little old ladies method. Got to remember this one. 43,560. 43,560 is how many square feet are in an acre. And I'm going to put that in the chat to kind of counteract the other guesses that are in the chat. 43,560. So, oh, wait. I did all that writing, and here we go. There's what I wrote. 4 little old ladies going 35 in a 60, or 4 plus 3 and 5 plus 6. Now, here is a lot in this lovely seafoam color. 212 feet are the front feet. That means the road. That's where the road is. And then it goes back 136 feet. That's the depth. That's it. Basic dimensions, 212 by 136. And we've put a little circle math in there just to show 212 times 136, multiply them together. How many square feet in this green square rectangle? 28,832. Length times width equals area. 9th grade, 8th grade, 12th grade, whichever one you did geometry in. Length times width equals area. That's what you need to know to figure the square footage in a shape. On the test, in real life, you probably, you'll run into 212 by 136, front times side, but you'll also run into lots that are shaped like this sometimes. So in real life, it gets a little more complicated, and you probably need a surveyor to tell you how many square feet are in a shape of a lot. But in this class, they're always like squares and rectangles. So since we're not giving you a license to be a surveyor, we're not going to get too crazy with testing you on that stuff. And then here's our square feet in an acre. So we need to change that 43.5 in the formula. How many acres? Here's the overarching question. How many acres in this lot? If it's got 28,832 square feet, how do we convert that many square feet into acres? We divide it by the number of square feet in an acre. Let me write it correctly. So here's our circle math. We have the number of square feet in an acre. Remember this. When we did the type of circle math that was annual tax, what was on the bottom? The rate. The rate was always a given. Well, think of it this way. The number of square feet in an acre is a given. Something that's a given, they tell you, here's a thing, is going to be on the bottom. So think of this sort of as the rate is. It's not a rate. Well, it sort of is because it's per, but it's a given. So maybe that'll help you remember it. Get rid of our tax reference here. So we had 28,832, which we got by multiplying length times width or depth to get the square footage, right? And that's it. Now that we have two things in this thing, what we're looking for is the number of acres. That's not hashtag acres. Hashtag wasn't always what this was called. It used to be called numbers. So 28,832 divided by the 43,560. Let's see here. 28,832 divided by the square feet in an acre tells me how many acres, and that means 0.66 acres. That is it to convert. What if what you know is the acres, and they're asking you how many square feet are in this thing? So what if it looks like this? What if they say the following lot has 0.93 acres? It's a 0.93 acre lot. Do you have enough to determine what is the square footage of that lot? You know, we think of acreage as the only way we refer to lot size, but I've seen some online some websites with property, and they have square footage of in other markets. They don't talk about lots in acres. They talk about lots in square feet. So it's the same thing. We just plug it in here. We need to know the square footage of the lot. That's up top. We already know the given, 43,560 is how many square feet in an acre. And we already know this, the 0.93 acres. So we just plug them in the right places. And by doing that, we now know that we need to multiply those two things on the bottom. 0.93 acres multiplied by square feet in an acre tells us that the total square feet of this lot is 40,510. And if we just kind of look at this from like a 30,000 foot view, 0.93 of an acre, that's not 1 acre, is it? It's not quite an acre. So 40,500 is not quite 43,560. So that matches up. That makes sense. And so now let's take it a little further. We know that the lot is 0.66 acres. The listed price per acre is $23,500. Now, you might be feeling overwhelmed right now, and that's normal. It's okay. I promise over the course of doing about 5 or 10 of these, it'll start to click, and you'll be like, oh, here's what I do next. So just hang in there, stick it out. You'll be okay if you're worried about that. No, Shane, they'll keep it simple. Great question. Will they make you calculate acreage on a weird shape? No, they'll keep it. It'll be a rectangle. They're not testing. That'd be calculus. They're not testing you on calculus. Just keeping it simple. So cost of land. How much is land? 23,500 per acre. So therefore, what is the cost of this lot? This lot is not an acre. We just calculated that the lot is less than an acre. It's 0.66 acres. So if this lot is 0.66 of an acre, then the price of it is 0.66 of 23.5, right? Think of it in that way. Therefore, those are the two things you're going to multiply together. That's what you're going to put on the bottom. The cost of a lot per acre of 23.5 times how much of an acre the lot is. It's like 60% of an acre. It's a little more than. So what's 0.66 times 23,500? The cost of this lot is 15,510. Does that help? Now, you don't have to use circle math for everything. For something like this part, you might kind of just intuitively have it in your head what you need to do. Multiply the amount of acres times the price per acre. You may not need to memorize all the circle formulas. And that's okay. Use what you need and disregard the rest. Thank you, Doug. There's more practice problems starting on page 666. I love that the math is on page 666 in this book. Appendix B starts on page 666. Yeah, definitely. Even if you're okay as a math person, just get back up to speed and go through that. Get a little refresher. I'll be putting some math videos together too. All right. Let's look at the next one. Lot dimensions, 300 feet by 700. 300 across the front, 700 in depth, depth, however you want to refer to it. Land is selling for $415 an acre. Yeah, that's the way we're writing it. Just think of it. That's a pretty good deal. $415 an acre. Therefore, how much will this lot cost? Ignore the extra credit. We'll come back to that. Let's take one thing at a time. First step. What do we need to know first to work toward this problem? I'm going to let you kind of think through it for a second while I be quiet. All right. Step one. We need to know what the square footage of this lot is. So we've got this shape, roughly. Let's pretend that's a real rectangle. 300 across the front, 700 across in the depth. 300 times 700. It's a lot. Literally. It's a lot and it's many. 210,000 square feet. 210,000 square feet within this lot shape. Now, we know our number of square feet, and we know how many square feet are in an acre. Let's work with those to get how many acres. Do some division. 210,000 divided by that 43,560 means this lot is 4.82 acres. We okay there? If we know how many acres are in this lot, and we know that it's selling for $415 per acre as given, second line, what do we need to do to calculate the cost of this lot? The number of acres times the dollars per acre. And that's why I say you may not need to think of everything in terms of a circle. That might just pop into your head because you go to the grocery store and you say, oh, one box of Oreos is $3 and it's 2 that I want. So it's going to be $6. You didn't need to draw out a circle for that. Something else to note here. What we need to do is take the number of acres, multiply it by the dollars per acre. What was it, 415? You have your calculator. You just plugged something in. Look at the calculator here. It says 4.82 and a whole bunch of numbers. You could choose to leave that in there and just hit your multiply by 415. And if you do that, you're going to get 2,000.6, we'll call it 69. If you instead cleared out your calculator and put in 4.82 and multiplied that by 415, you're going to get 2,000.3 because of rounding. Don't worry about it. Here's some good news. They're not trying to teach you about rounding and the real estate commission test. They're trying to teach you about real estate laws and rules. Therefore, they will never give you two different answers out of the four that are this kind of apart. They'll be way more apart than just this. They're not going to try to trick you with a rounding error. So if you're pretty close, then it'll be clear. Instead of 2,000.69 and 2,000.3, they'll give you, let's say, 2,000.3, and the other answer choices are 2010 and 1993. It'll be that. It'll be way more than what a rounding error would cause you to get wrong. And I think the overarching procedure suggested about rounding is to round to 2 decimal points. I tend to like to just leave it for the sake of time. I like to just leave the number in the calculator and keep on calculating so as not to have to punch in and over again, clear and punch back in, and then I'll round the last thing I get. When I get to the final answer, that's the one I'll round to the 2 decimal points. But rounding won't mess you up. So here's what it looks like. It was 300 times 700 was 210, and then the 210 divided by the square feet in an acre gave us the 4.82. And then the 4.82 acres times the the dollars per acre gives us a lot cost of $2,000.69. Obviously, John, I think, wrote this, and he clearly used the non-rounded version straight out of the calculator, which is what I do. Then here's the extra credit. They went on to ask you this question. What is the cost if the lot is selling for $900 as front foot? Forget the $415 per square foot. This is a commercial property. In commercial real estate, you see a lot of reference to front feet. Why is that? Why does a commercial property matter more that it's front footage than square footage, perhaps, in terms of value? Think stores. Yeah. Access, street access. I think about driving down like through Dilworth, Myers Park, and you're looking at the shopping centers. And if you miss it, if you blink, you're going to miss that little store because it's right there and it only has like 50 feet of road frontage. The more road frontage you have, the more exposure, the higher the price point. So in this case, let's say it's a commercial property and they don't care about square footage or acres so much as they want to get paid per front foot. And they're selling that lot $900 per front foot. What's the math look like to calculate how much that lost lot will cost for $900 per front foot? What are we multiplying together? Well, I'm showing it to you. Yeah. Did you guys hear that crazy noise just now? Probably not. I have a gravel pit like within 2 miles of my house, and occasionally dynamite blows me out of my chair. It used to scare me to death every time, but I think I'm getting used to it. My poor dog gets scared though. 900 times 300 priced per front foot. Which one would you rather make? Do you want to make $20,000 because you're selling it per acre? Or do you want to make $270,000 because you're selling it per front foot? Right. That's it. That is the conversion of square footage to acres. I'll give you some more exercises. I'll pull some things out of air and give them to you to help, but also don't forget your math appendix. Let's also don't forget our break. Come on back at 12:10. Please and thank you. Yes, we're back. Welcome back. Last hour of this session. Hope it's going down smooth. As we get into chapter 5, let's talk about land use controls. When we get to chapter 6, by the way, that one's going to fly because it's about environmental stuff and you don't have to know that much. Environmental talks about underground storage tanks and asbestos, lead-based paint, and mold and all that fun stuff, but it's fun to look at the gross pictures, but it doesn't go by very far. There's only a few things you'll be tested on out of those things. Okay, there we go. As a reminder, relink. There it is. Environmental, 3 on the national. Environmental issues. Land use controls, what we're getting into now, 2 on the national, 1 on the state. So it requires a little more time in class, but it's still not much testable material coming out of this. Here we are. Land use controls, what can you do with it? That's what we're talking about. You know, back when we first got into the scary legal stuff like fee simple absolute, I said you can do whatever you want with it, but that doesn't exactly, it's not exactly the way it is. Fee simple absolute just means that the seller you're buying it from isn't telling you what you can do with it. You're still buying it subject to the zoning laws, subject to the private land use controls. And when it comes to land use controls, there are both public and private. So, objectives here. How are they created? What are the public controls? What do the private ones look like? What's some terminology and authority and procedure? When you drive by one of these, there's some contact information at the bottom. There's maybe a website, a phone number, and it means that something near you as you're driving is a piece of land that the zoning is going to be changed or proposed to be changed. So when you see this one, think government, police power, zoning, not private, but government. Good old blue Z on a yellow background. There's a rezoning notice. And if it's safe to pull over and go to that sign, if you can't see it from your seat, go take a look, take a picture, then go visit it. Go see what that zoning change that's being proposed is, or take a note of where you are, the address, or the intersection, and go look it up on the local government website. Upcoming zoning meetings. We're going to talk about this. And on my street, once upon a time, there was a church at the end of the street, and they owned property on both sides of the road. I was the last property before them. They proposed to the government, city, let us have the road from the end of Neal's property all the way to the dead end, because we're getting people like parking at the end at night, and that's not attractive. And we own on both sides, so we want to have our members be able to go back and forth. And I'm all about, being low key. But in the interest of my future property value, I kind of always wondered, I'm only a mile from a next exit. Maybe someday they'll put a service road in to the exit, and therefore this becomes from a dead end road to an outlet road that goes to an exit, and that might add value to my property. Therefore, I showed up to the zoning meeting and in protest. I mean, I didn't have a sign, but I did speak, and I said, look, I think this could affect my and the other 4 or 5 at the time residential owners' values if you give them the road from to the end. But they ruled against me because 12 church members showed up, and they were all talking about the kids doing whatever they do with the road at the end, and it worked. And okay, fine. But it turned out to work because the fact that there was a church and subsequently a daycare and now a school and blah, 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 resulted in lots of traffic. And normally you don't want traffic, but I do, because drive-by traffic is good for commercial type property, car count, that sort of thing. It all worked out. So go to a zoning meeting. You could possibly even go to one without going there and log in. They have zoning meetings as of last couple of years. You could probably witness one, fall asleep in one without having to sleep there. You could just sleep in your couch while you're watching it. The government has a right to enact and enforce laws, again, for the public good. Governing land use. What's it zoned? It's because, anybody ever played SimCity? That's an old game from way back, SimCity. And you would draw out your grid. You'd say, on this grid, we want to we're going to have a little lake over here. So we want this to be the residential area. And because we want to get close to the Starbucks, we're going to have this the commercial area. And the old stinky, industrial area, we're going to put way over here. And then this will be our natural area, so maybe some agriculture. And then you hit go and people start occupying and you start deciding what to spend money on roads and how many to put and should you blow it all out and spend it all now and have zero left. And you basically act as a mayor. And inevitably you completely run it in the ditch because it's harder than it looks. This is real life because you don't want to live next to the asphalt plant, right? And while that church did kind of go up against me, or I went up against them, I was still thankful they were there because the alternative literally was the previous owner, my previous neighbor, was considering selling to an asphalt plant. So I was thankful to have a church, period, regardless of if they took the road over or not. Planning and zoning. Any given town has a department of planning and zoning. Building codes fall into this. You can't just build whatever you want, wherever you want, even on your own property. If it's something that is going to be structural, where people could occupy it in the interest of the public good, i.e. the visitors to your house, if you didn't build it right and it falls down and kills somebody, that's a concern for the public good. Therefore, you got to build that sunroom according to building code. And if you don't, there's nobody just posted outside of your house watching to see what you do. But if you go to sell it, that buyer's agent, if it's a good one, is going to say, we need to check, see if that sunroom they added 2 years ago was built with a permit. That's when that can come to light. And that's when that sunroom could possibly have to get torn down and rebuilt properly. Oh, I'm so proud of it. I built this myself, me and my son, with our own 2 hands. Oh, great. Did you get a permit? I didn't need a permit. It was just for myself. Well, yeah, you didn't then maybe, but you do now because you're selling it. Can you retroactively get a permit? Maybe not. The city permit inspector guy is going to come out and say, I can't see inside those walls. I don't know if you did the electrical right or the plumbing right. And it might require pulling those walls apart to look inside, or worse, taking the whole thing down and just rebuilding it. It gets expensive. Building codes, it's a big deal. As brokers, it all comes back around to our liability as brokers, as protecting the consumer. As brokers, we need to ask, was there a permit? And if there wasn't, tell everybody. It's a material fact that there was not a permit granted for this addition. Police power of the government also regulates land development, what you can do with the land where. That's why they're telling me I could have had this place sold. I have my property on the market. 2 years ago, I could have sold it to somebody that wanted to put townhouses on it, but that would require residential zoning. And it's zoned industrial. And from what I've been told, the city of Concord is not giving up any of their industrial zoned property. So I got to wait for the buyer that needs industrial zoning. Here's what we're responsible for as brokers: to discover and disclose. We need to make sure it's zoned properly, especially if it's important to our client, and especially before making an offer, because when you make an offer and it gets accepted, now your buyer client is on the hook for writing checks. If their offer is accepted, they have to put in earnest money that they agreed to, something else called due diligence money, which is even crazier even now. So we as brokers need to make sure it's right and going to serve our buyer's purpose before we obligate them to a contract. General public, the good of safety and welfare, health, safety, and welfare of the general public. There's also a long-term, long-range zoning plan you could probably find in your given town's website or city's website. Shows kind of what they have in mind for the far future. Right now, Concord and Kannapolis are really starting to spend some serious money because both of those towns have big $1 million, multi-million-dollar projects that are finally breaking ground. New courthouse facility in Concord. Kannapolis in the last few years cut off their main downtown major road, turned it into a pedestrian-friendly road with shops and stuff. And it's all kind of coming together finally. So there was, for many years, those plans on the books. You could see what the plan was, and now it's starting to actually come into fruition. Zoning, subdivision regulations, building codes, environmental. What can you do where? Lake Norman, right? Because now you've got water, which means animals, which means wildlife, flora, and fauna. Got to make sure we don't just clear cut everything and drive out all the animals. Got to keep it pretty safe for them. Keep habitats in place. The coast, same. Especially in waterways where fresh water meets salt water. That's a very unique ecosystem. So there's definitely some guidelines, required governmental guidelines, environmental regulations, making sure that they're not dredging things and causing problems where something that used to live in a body of water can no longer survive there because the things were upset. Things were, because of building, made uninhabitable. Public land use control zoning is enacted by the local government. It's also enforced by the local government. Zoning is this concept of a police power. The cops aren't coming out and doing it, but it means the government is involved, and therefore they are enforcing the zoning requirements. If you have a problem, you're going to contact the government authorities and say, hey, somebody's not using this as they're supposed to under zoning, and the city will send them a letter. As such, I live in an industrial zoned area. There's a daycare down the street. I also let my friends who own a moving company park on my vacant lot. It's all fine. Except when somebody who's going to the daycare gets mad because my buddy's moving truck clogged the road for like 2 minutes as he tried to back in. This is what I think happened. I think that happened. And somebody looked around, saw my property, saw my Chevrolet or Ford Expedition that at the time did not have a tag on it because it was just in a park in the driveway, tagless, and turned me in. And I got a letter from the city, and that letter said, hey, you're in a residential area. You're not allowed to have an untagged vehicle. I'm first of all thinking, who told on me? Second of all, I'm okay with this because this is not a residential area, and I took more pleasure than I should have in calling that guy from the zoning department. I wasn't mean to him. He was just carrying out their wishes, but he sent me a letter without checking. And I said, well, I got this letter. It says residential, no tag, not allowed. He's like, yeah, that's right. I'm like, well, the thing is, this is zoned industrial, not residential. Oh. Papers, typey. Oh, well, you're right. Okay, no problem, disregard the letter. I'm like, who would have turned me in? And I think it was that, because those guys have to back their moving truck and probably cause somebody 30 seconds of inconvenience. So, police power. City sent me a letter. They also sent me a letter saying, you have this amount of square footage of impervious area. That means water runoff. Impervious means water can't soak down through the grass. Like in your front yard, water soaks down through the dirt, but in your driveway, it can't. That is impervious. Water would have to run off, and that becomes a problem if you have too much water runoff in a given area. It causes erosion and all kinds of problems. I think from the aerial GIS view, somebody saw my vacant lot, thought it was a cement lot. It is not. It is gravel. It is pervious, not impervious. I got a letter years ago. You have impervious area. You're going to have to pay $1,000, blah, 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 because turns out it all worked out. It was, in fact, maybe they should start sending folks out to check further before they just fire off a letter. So long story short, if your client gets a letter, first of all, figure out if it's even valid before anybody gets in an uproar. But that's how it goes. Regulation examples. Zoning applies to lot sizes, setbacks. Did you know that if you have a lot that looks like this, you cannot build? Wouldn't it be nice if you just want to maximize? It's like a nice 3-acre lot, 3 acres. And you're like, where am I going to build my house? Well, I don't want it up here on the road. Let's just stick it right back here on the far corner. Or maybe instead of that, let's put it like right here on the side, all the way snuggled up to the side. And then I have all this fun big lot size. Maybe I want to build a bigger, like a, studio, garage, whatever. Probably not going to work out for you because the city says you can't do that. You can't build all the way up on your property line. We have required setback lines, which you'll see if you look at a survey. And many times those setback lines are further back on the front because they want you back off the road a bit and not quite so far back on the sides, maybe a little further back on the back. And so your house footprint has to be within that footprint of the setback lines. That's a zoning thing. That's a city thing. That's a police power. Heights of buildings, that matters downtown. Are you ruining natural light? Are you ruining a view of some sort? Can you just build a huge 20-story building next to a residential area? Maybe, maybe not. What can you do with the land? Obviously, protection of natural resources we talked about. Style, type, and appearance. Places like Dilworth and Myers Park are only so big. Myers Park is not going to extend 50 miles from where it is now. It is only as big as it is. That's what makes it worth more in uptown Charlotte. Well, there may be like historic issues in areas like that. And in a historic district, there's what's called an overlay zoning. On top of the residential zoning, there's a historic district zoning layer, which means not only now, only you can only live there. You can't have commercial there. It's got to be a residential, but also you are in an old house in the historic district. Therefore, we need to maintain the appearance true to the age and the era. Oh, your front door needs to be replaced? You can't go to Lowe's and buy a $300 steel front door and stick it up. You're going to have one made, custom, to match the era of that historical period because you live in an historic district. That's the ins and outs of zoning issues. Guess what a custom-made front door costs compared to a $300 steel from Lowe's? A lot more. But that's the deal. That's what you get for living in a historic district. Buffer zones are land areas that separate two different kinds of uses. Sort of a buffer zone between like maybe commercial and industrial to give it a little bit of space because the industrial is really noisy. The commercial is probably noisy too, but that has traffic, like foot traffic, pedestrians, customers coming in, and they don't want to see the asphalt plant either. So there's a certain required buffer zone between the restaurant row and the landfill or the asphalt plant. Cluster zoning is when there's flexibility of density. Flexible use of density, meaning what's density? How many people per acre? It's that kind of an idea. So a multifamily community, think townhouse, right? Under one roof, there's probably 4 townhouses, maybe 5, maybe 3, maybe 2. Multiple separate people, separate owners. And that's zoned for greater density because you can fit more people in that, and it's okay because they live in townhouses that are attached to each other. So the zoning required for a townhouse section of residential area is probably R10, whereas the zoning required for a single family area where it's a house, like just a single house, neighborhood of single houses, maybe R2, R3, 4. R3 might mean 3 houses per acre, so average lot size, 1/3 of an acre. It's not in stone. Some of these things depend on the county, the city that you're in, but that's the general idea. So how multifamily is placed. There's a neighborhood called Highland Creek near my house, and it's ultimately, I think they got up to over 4,000 total houses. When I was new in the business, they were halfway finished. And Highland Creek, let's just say it's a nice, tidy little square like this. It's got single-family residential houses all in the front and probably back here too. There's a golf course that meanders around. Now that it's been kind of completed, there's a section for 55 and older. There's a little community of that. That requires its own certain zoning too. That is a higher density zoning requirement. Then there's a townhouse section over here that's maybe like R10. This might be like R4. Back here might be R12, or I'm just making things up now, but get higher R amounts, higher density amounts per project, but it's all within the same development because it's what's called a PUD, planned unit development. It's got a mix, single family and multifamily. Another testable term you'll run into is something called extraterritorial jurisdiction. This extraterritorial jurisdiction concept, we just got finished talking about how zoning laws apply in the, say, for instance, city limits, county limits. Just because the zoning rules pretty much in the limits of the town, extraterritorial jurisdiction means that they can even have some say over what goes on 1 to 3 miles outside of those limits, because it could indirectly affect the city, the limits themselves. Municipalities have authority to regulate adjacent areas 1 to 3 miles outside of the drawn lines. That's what we're talking about with extraterritorial jurisdiction. Outside of the limits is still applicable. The zoning laws are still applicable. Zoning ordinances must be exercised reasonably. It can't be unfair. It's got to be for the public good. They can't benefit one party and not the others. It's got to benefit everybody kind of equally. That's what we're after here. Can't violate the rights of any one given property owner. It's got to be specific. You can't just leave it abstract. It's got to be free from discrimination. Obviously, everything we do in real estate, overarching, I think it's still chapter 19, is fair housing. There's categories of fair housing. We'll get into that in the listing agreement. All of our agency agreements are subject to fairness in fair housing. We must be fair and treat everybody the same without regard to familial status. That means, is there an underage child present? Race, religion, sex, handicap, national origin, color. I think that's all 7. I might have missed one. So the same here. Zoning must be free from discrimination, must apply to all properties similarly. There's another term called legal non-conforming use. Well, it's legal, but it's not conforming to the existing zoning status. And it's exactly my situation, because I bought the house I grew up in 2001. So once upon a time, this was, I think, even agricultural. Then it turned residential when my parents bought it. Then I bought it. And then somewhere while I was the owner, it went from residential to industrial. But I get to still use it as residential because I was here first before it changed. I have a legal non-conforming use. I don't conform to the use of industrial, but it's illegal. And the term grandfathered in comes into play here. Anybody heard of that term? I was here first, so they're not going to be able to drive me out. Now, if the house blows away, they won't probably let me rebuild it. Because when you're non-conforming use, you can't vastly change the house. You can't even repair it past a minimal amount. You can't rebuild or add on because you're under a legal non-conforming use. You're grandfathered in. They're not going to let it be that way forever. The idea is that eventually it will morph into an actual industrial use, but they're not going to bully me to do so. It no longer conforms. I'm able to continue as a matter of right, but I have restrictions. I can't expand on it. I couldn't build a whole nother wing. When I applied for the building permit, they would probably realize, oh, wait, you're zoned industrial. No, we deny that. No, you're not allowed to do that. I wouldn't mind. I love the location because it's convenient. I wouldn't mind going up to the back part of my property up in the woods and building a nice custom house that has things that have modern conveniences, this and that and the other. But that's a residential use. I can't raise the roof here and add a layer because that would be too significant. I'm only grandfathered in. I get to live in it as it is. I can keep it painted and upkeep it, keep it safe and habitable, but I can't go crazy. Another zoning term is a variance. A variance is a case where the owner is suffering a hardship because of the use case, because of the type of zoning it is causing that owner to have some sort of an undue hardship that is not fair to them. And so therefore they are given a variance to have permission to deviate from the zoning use. But they need to prove it. They have to prove they have an undue hardship in order to deviate from the existing zoning category. One example might be that perhaps through the condemnation of eminent domain, an owner lost some of his road frontage, and all that's left, because of the way the project had to be, was something that was not allowing enough of a setback line. Like, say they eminent domained him. Is that a verb? I think I made it one. And they chopped off his front yard. And here's his house. But the setback line requirement is, let's say, 40 feet from here to here. Well, they just took half of it, and now all he's got is 20. He would be given a variance because through no fault of his own, he's suffering a hardship, and now all he's got is a 20-foot, and he's normally required to have a 40, but he didn't. It wasn't his fault, right? They condemned him through eminent domain. So he would have a variance to the normal zoning because he could prove that undue hardship. Another zoning term is special use. If it doesn't comply with the existing, you could allow a property to be used for a special use. Again, it couldn't be because he's the cousin of a person on the zoning board. It would have to be a reasonable accommodation to allow a property to be used for. Here's the overlay district we were talking about. Historic. We've got a residentially zoned part of town, and the historic preservation zoning lays over top of it, which means, yes, you can only use it for residential, but also more than that. If anything falls off or has to be repaired, you better do the repair as per the original era, not just whatever's cheapest from Home Depot, right? You want to put gutters on it? Well, you're probably going to need custom copper gutters because that's what was on it before. They rotted out and you want new ones? Sorry. The $20 a foot gutters from Lowe's, not going to do it. The white ones, nope, got to be copper again because it's a historic preservation zoning layer. Also aesthetic zoning. You've got parts of city that need to look a certain way. You might have seen those cell towers. This is a small picture that look like trees. Cell towers that look like fake trees, I should say, because everybody knows that's not a tree. First of all, it's 50 feet higher than all the other trees, but it's at least prettier than a tower, I guess. Here's something that's bad. Spot zoning. Immediately think bad, illegal, not allowed. Spot zoning. This is the kind of case where maybe it's the uncle to the person on the zoning board, and he somehow skidded some wheels and got some things worked out. So that uncle gets to use his property in a way that nobody else around him does, just because he's special. The old network, right? Spot zoning benefits the owner. It's inconsistent with the public good. It's only for the benefit of that owner, and it is not allowed. It is illegal. Spot zoning, not allowed. What do we as brokers need to do if a customer or client has a question about the zoning or usage? Do we say, oh, I know all about this. Let me give you my legal opinion. What's our best case here? Yes, shed it off of your shoulders. Do not give opinions. That is legal, upside down and backwards all day long. Point them in the right direction. Now, I might take it to the next level, help them be more full service and say, here's the phone number, or here's the website, or maybe even contact zoning myself and then say, I already talked to them. Looks like this, but you need to talk to them. I don't know. I probably wouldn't do that because they might be tempted not to talk to them because I did, and then I've gone on record, and so I don't want to do that. But yeah, point them to the right authorities. That is not you. Have them contact zoning themselves. You could assist them, point them in the right way, guide them through the website, phone number, but have them get the information straight from the horse's mouth, so to speak. We already talked about a subdivision a little bit. How many lots does a lot need to be divided into to be legally considered a subdivision? And it is surprisingly 2. There are regulations surrounding creating a subdivision. Normally it's more than 2, but that is what is required to meet the legal standard. Subdivision ordinances. City and county laws govern how subdivisions are created. 2 or more lots is all it takes for it to be considered a subdivision. Now it's got to fall within whatever the subdivision ordinances are for that town, city, county, because you divided it. I know a family right now who they're all 3 building, and they're building three different families, right? They're all related. It's the parents, and then it's 2 older families, kids of those parents with their own kids. So the parents, I would imagine, are like 70s. Each of the kids' families, the parents are like 35, 40, and they each have 3 kids, like little kids, single-digit kids. And they're all sharing 10 acres within, obviously, walking distance of each other. which is kind of cool. But when they bought that 10 acres together and divided it into 3 lots, they made themselves a little subdivision, even though it's only 3. And they are required to adhere to whatever the ordinances of subdivisions are in Locust, North Carolina, because that's where it's located. And that's different from Concord or Charlotte because it's locally governed. The process of creating a subdivision requires a preliminary plan. Hey, city wants to know, what are you going to do with it? What's your plan? Find the land, prepare it, plan for it, submit a preliminary plan of what you have in mind, because that's going to impact road access, burden on the surrounding areas and utilities. The final planning stage involves purchasing that land, financing the land, and then starting up the project, breaking ground, moving dirt. Involves recording plans, construction, selling, and transfer. Sort of the big overarching top 3: preliminary plan, final planning stage, and then the actual startup. So it matters to us as brokers because when can the developer actually sell property? Can they sell it in the preliminary plan when they're still just kind of looking around? Obviously not. Near the Charlotte Motor Speedway, once upon a time, in the glory days, probably 2004 maybe, off of Moorhead Road, the plan was a big golf and tennis complex. And who is that? Little tennis star from way back when. Oh, I just blanked on her name. She came out and did like a exhibition match. They made a tennis court on the corner of Moorhead Road and 29. No, not Martina. I'll think of it in a minute. I went because they're going to also build houses. Come to find out, the whole project collapsed because they got a little eager and they started building property. So they actually started building the golf course on acreage they didn't quite close on yet. They didn't even own it, and they started building it. And some builders actually went ahead and started building property and building spec homes. Back then, you could build a home on speculation because you felt pretty confident it was going to sell to somebody. Then in the past couple of years, they started only building homes that were guaranteed because somebody wanted them to build it. They're not just going to float it and build it and let it sit there because they weren't sure that it would get sold quickly enough because, once a builder builds it, they want it sold. Well, the whole project fell apart out there. It was going to be huge, this huge tennis facility plus golf course. And they sold things without the proper order. Selling lots, you can go under contract. A developer can sell you a lot in a new construction community as long as they have a preliminary plat map approval. They draw that plat map and they tell the city, here's what it's going to look like. And the city stamps it and says, okay, this is your preliminary plat approval. They can sell contracts based on that. They can't close on them based on that, though. That's a testable question. The preliminary plat approval is okay to go under contract, but not okay to close. You've got to have a final plat approval in order to close. Because if somebody wants to buy a property, you can't ask them to close on it without them knowing absolutely for sure 100% that that's what it's going to look like, how things are going to be laid out, where their property lines are going to be, where the road is going to be. Yeah. So final plat approval and recordation has to happen before closing, or it's illegal. Does not comply with subdivision regulations. It's considered a criminal act. You would have closed on lots in an unapproved subdivision. So you'd be subject to that deal falling through, but also criminal consequences. So if you're going to sell new construction and maybe talk to developers and get on that side of things, not a bad idea to look up the subdivision ordinances in the markets you will serve. Another hugely important concept, both in real life, but also just in this test, is streets. Streets in a subdivision. You ever driven through the subdivision and you hit the manhole cover and it's like jarring? You think you just broke your tire because it was 3 inches above the pavement. That's because that's not the final layer of pavement, right? They're waiting for the dump trucks to ruin it because they're going to do that while they build phase 3 and 4. Then they'll put the final layer when it's all pretty much done. Then everything's nice and flush and level. But odds are those streets in that subdivision, no matter how pretty and perfect and how good they look, and maybe they look exactly like a street on Trade and Tryon, perfectly obviously city maintained, they're not. They have not yet been given over to the DOT for maintenance. Sort of like that mobile home thing. You've got to build the street to DOT standards. That developer has to make sure those roads and streets and curb and gutter, all that runoff and all the perfect build of it is done to the standards of the Department of Transportation of the state, North Carolina DOT. Then, once they're finished, they will petition the NCDOT to accept those streets. And that's still not good enough. The DOT has to say, yep, okay, we'll take care of it. If all three of those steps don't happen and they petition to turn these private roads over to become public roads, which means basically the state of North Carolina will repair them, keep them in repair, then you have public roads, private roads, not public roads. And you as a broker, you go in and see one of those houses to list it. You talk to that seller. You say, hey, I know this is a relatively new subdivision. Just curious, do you know if these are publicly maintained roads or not? And they might say, well, they look good to me. It's on you to dig deeper. Got to make sure that who's maintaining them, because right now the first 2 or 3 years is fine. They're going to be fine. They're still going to look good. But year 10, 15, 20, when potholes start to get bad, whoever's living on that road and wants them fixed, they call the city and say, hey, these potholes are out of control. You need to come over here. And the city will type, sorry, sir, but those are not publicly maintained roads. That's your problem. And then you and the neighbors are footing the bill to repave the road. And then one of those neighbors is your client from 5 years ago, and they call you and say, hey, remember me? You're like, yeah, hey, we have a problem. And your belly falls out of your feet. And they say, do you have anywhere in the paperwork about this being a publicly maintained road versus private? You could have a problem. You need to make sure that you are discovering and disclosing if these are publicly maintained or private. And if you look at any given new construction contract, D.R. Horton, Niblock, whoever's out there building now, Ryan Homes, they're all 30, 40, 50, 80 pages long. You as the broker, you don't just say, oh, sign there and sit back while they're dealing with the on-site agent and you don't do much. You need to read through that whole thing. See how it matches up with the existing normal contract 2T and point out to your client the differences and say, oh, see client over here, you're having to pay buyer's having to pay the excise tax in a normal transaction with a 2T document. Seller usually pays, but no big deal. It's just the way it is. Just pointing that out to you. Also, look right here. Usually it will say in a new construction contract, currently the roads are private. The seller developer has not yet turned them over to the state, but we've built them to the specs. We don't see it being a problem. Buyer needs to initial here, acknowledging that they're aware these are private roads at this point, but we're going to try to make them public eventually. That is part of the contract, you'll probably find. Got to be built to DOT standards. Then the developer petitions the DOT, please accept them as public. We don't want them private anymore. You keep them up from here forward. Then they have to accept it. That's a very testable question. Did they accept it? They'll paint a narrative picture. They'll write a paragraph about it. Joe Blow buyer did this and the developer said this. And is this a publicly maintained road? Somewhere in there it probably says it was not accepted by the DOT. And so the answer is no, it's not a publicly maintained road. What's another guarantee that it's a privately maintained road, not public? One of the stipulations of it being a publicly maintained road is that it is accessible by the public. I know I just blew your mind. That's a brilliant statement, wasn't it? But think about any gated community. Is that accessible to the public? Those are privately maintained roads. Do you think they're worried about it? Because those gated communities are probably pretty steeply priced. They're okay with that. You know, they'll cover it when they need to. It's probably part of the HOA fees is they set aside, escrow aside money so that when they do need to repave them, it's there to be done, but it's not publicly maintained. They can't if they put a gate on it. North Carolina law requires that the developer disclose whether it's public or private as to status of streets. It's in that contract somewhere. We as brokers need to verify and tell them, make sure our buyer client knows this. And there's a resource for that. There's a resource, nc1map.gov. It's where you can find out if something is public or private. It's not always new construction either. I sold a house on 27 acres and it had the driveway, but then about 100 feet down on the same busy road that the driveway is on, there was a road, looked like a normal road. But when you look a little closer, you realize, oh, it's gravel, but it has a green road sign. But it turned out to be privately maintained, not publicly maintained. If you weren't really paying attention and doing your research, you would assume, and that's always a problem. All you got to do is plug it in to the website. Is this road? Here's the name of it. Is this an actual DOT public road? There it is again. nc1map.gov. You won't be tested on that website, but you just need to know to do your discovery and disclosure. So whose responsibility is it to discover and disclose public and private roads? You tell me in the chat. Oh, that was interesting, Ashley. That's a long story, but I'll tell you the short version. First of all, this 27 acres, it was a log cabin on 27 acres. They corrected me when I called it that. They said, no, it's a cabin home, or what do they call it? A log home. That's what they called it. Because it was like a kit. It was a really nice kit. And between the cabin home, that's how I just called it, and the 27 acres and the pasture and the barns and the hand-built 2-story hunting cabin, 16 feet square, that they built themselves as 60-year-olds just because, they needed something to do for fun. Up on the hill back in the woods, off-grid with its own toilet in an outhouse. I mean, nobody knew that was there until I told everybody in the marketing. First, they tried to sell it. I might have told you the story. With a broker, they just called out of the phone book, and she said, what do you want to sell it for? And they were thinking of all the sweat equity, all the labor. And they said, how about $800,000? And she said, okay, if that's what it takes to get my sign in front of this awesome property. And 2 years later, nothing. 800, 750, 700, 650, still nothing. And his son was a guy I went to school with, and I got the opportunity, and I said, I had to give him the bad news. Sorry, this is worth $400,000. And that's what it sold for. I ended up being a dual agent.
27 acres? Only 400,000?
Well, this was
with all of those amenities?
6 or 7 acres. I'm sorry, 6 or 7 years ago. And it was in North Wilkesboro. So a little more rural, a little more mountainous. The limit of how far away I would go for property. But it's all about location, isn't it? I think if they could have, but they had to sell because her dad was aging and they needed to get to the beach to take care of him, health reasons. But if they could have held on for another 5 years until maybe this past year or two ago, they would have gotten it. They'd have probably gotten it. Plus, it was kind of unique. So that's always different, is the valuation of something that's not the norm in real estate is usually going to go negative. You're going to have to take less for your house if it's unusual, like an octagon-shaped house compared to a traditional type house. Fewer buyers for something unique. We'll learn more about that in valuation. So building codes are a local standard of construction. Local, whatever your local jurisdiction says. Building permits are required to make sure they are sticking to the building code. That involves an inspector from the city coming out and saying, yep, okay, checking off. Now you've built the foundation. Now I'm checking that's good. You've built the walls. Okay, good. So it's multiple visits, this process. Oh, now it's time to put the electrical in. Okay, let me come out and make sure you did that right. And the plumbing and the roof, right? Finally, they'll give a certificate of occupancy, also known as the CO. Certificate of occupancy is what is required for it to be closed. So somebody can actually safely live in it, inhabit it. Inspections are completed. It's safe to move in. That's when you can close on new construction. The Interstate Land Sales Disclosure Act. When I see this, I think of the like in movies and TV shows where, or that saying, or somebody says, well, if you believe that, I've got some land in Florida to sell you, right? Or a bridge to sell you. It's the idea that somebody fraudulently and unscrupulously came up to, let's say, here and said, hey, we're selling land in Florida. It looks like this, and showed pictures. Do you want to buy it? And you buy it sight unseen. And then you finally go down there to find out that it's terrible or it's swampland. So the Interstate Land Sales Full Disclosure Act says that if it's a 25 or more lot development, they've got to give you full disclosure. They've got to fully disclose to purchasers a property report. You can't buy it, even if it's sight unseen, you can't buy it ignorantly. They've got to tell you the full deal with it. And you also have the opportunity to back out of the purchase, an amount of time that you can rescind the contract, which means, oh, buyer's remorse. Nope, not quite what I thought once I finally saw it. There's a right to rescind the contract. That means get out of it. And if that developer violates this Full Disclosure Act, when it's across state lines of 25 or more lots, they are subject to both civil lawsuits and criminal prosecution. Okay, we just finished up our class. This is just me talking to you guys after the fact. Everybody just exited the Zoom room. Recap. We covered most of 5. Most of 5, we just have like 10 more points to make here under chapter 5. Then we're going to get into 6, which is environmental issues. That will go by pretty fast. I just provided over the weekend the OTPC, offer to purchase and contract, as well as the agency agreements. The listing agreement, I still need to give you the buyer agency agreement. So you'll be wanting to look those things over in anticipation of the listing agreement, at least before we get into 7 and 8. And then 7 and 8 is what's starting. 7 will start on Wednesday. Probably the second hour, we'll get into 7. And we'll spend pretty much the entire time on 7. And then the following day, Labor Day, Monday the 5th, we do not have class. We do not have class that Monday. So there will be a week between 7 and 8. Work on some math, conversion from acreage to square feet, and excise tax. Don't forget the excise tax. Don't forget your math appendix, page 666 in the textbook. I think that'll do it. You reach out to me if you have any issues, and we'll see you on Wednesday. Have a great couple of days.